All right. Welcome, everybody. Good morning. My name is Dana Sparks. I am the director of the Georgia Real Estate Academy, which is the school that is offering this course for CE credit. It is 3 hours of continuing education credit. And this course is, drum roll please, this class is the 2021. Woo! Are we not all happy to hear that year? The 2021 Georgia Association of Realtors, or GAR, contract changes. I believe we are the first to offer this class to agents. If not the first, one of the first. I know there are other schools offering it throughout the month, but we are so excited to be able to bring this information to agents throughout all of Georgia. And I am really curious to hear, as we go along, your thoughts regarding the changes that the Contracts Form Committee for the Georgia Association of Realtors has made to the contracts. So,
Dana,
we will get started. Yes, ma'am.
Did you say this is the contract changes or the dissection of the whole contract?
No, this is just the changes. This is not verbatim contract. This is just the changes that GAR made from 2020 to 2021, but there is 3 hours worth of material. It's a different class that the Georgia Real Estate Academy offers called Contract Dissection. And I apologize, I believe the name got switched. It was accidental. We do offer another class called 2021 Contract Dissection that we will offer a little bit later on in 2021, where it does go through the entire GAR purchase and sale agreement, financing form, so forth and so on. But today's class is not a contract. It's not going through the entire GAR forms or contracts. It is just addressing the changes that the GAR Forms Committee made from 2020 to 2021. So thank you, McKay, for that question. I apologize. I hope to make that clarification. And if anybody—
Is it a different course number then, Dana, than what's
Yes,
on the calendar? Okay.
No. The course number is correct. The title was incorrect.
Okay.
It is 20. This is 2021 GAR contract changes, but that is a perfect segue into getting started with the notice to students. So I'm going to get started. There is 3 hours worth of material of the changes. But if any of you, I see a lot of familiar faces, so I know a lot of you have taken my classes before. You guys know that I like to input a lot of additional information, which I have also done for this class, to help you guys as agents so that you become more knowledgeable and more confident yourself in your chosen career, and to give you information so that you are a better service provider to your clients, to be able to explain to them some of the contract issues if they have questions. So you'll see that'll make a little bit more sense as we go through. So again, my name is Dana Sparks. I am the director of the Georgia Real Estate Academy. I am also the qualifying broker of Maximum One Greater Atlanta Realtors. I only tell you that because I'm a non-competing broker, meaning I don't continue to actively interact with the public with helping them with their real estate needs. I just manage, I just teach and manage and broker. But I do see contracts on a regular basis. I don't see every contract. We've got compliance brokers that see every contract. I just see contracts that have issues or questions or dive in there to help. So again, any interactions and questions, please type them into the chat, and we are going to get started. So I am going to share my screen, and I am going to start. Let's start at the beginning. I think that would be a good thing. That's always a good place to start. Like in The Sound of Music, let's start at the very beginning. Very good place to start. Now let me find slideshow. There we go. All right. Here we go, everybody. 2021 GAR stands for Georgia Association of Realtors contract changes. This is GREC course number 72468. It is hosted by Maximum One Greater Atlanta Realtors. I am the instructor. Again, my name is Dana Sparks. There is my contact information there. CE credit is offered through the Georgia Real Estate Academy, which is GREC School number 6915. Notice to students for the virtual broadcast of continuing education classes of GREC approved classroom classes. The Georgia Real Estate Academy, which is GREC School number 6915, with the end date of renewal being December 31st, 2022, presents to you the following course of study. 2021, yay! GAR Contract Changes, GREC course number 72468. This is a virtual remote broadcast of an approved in-class course. It is 3 hours in duration and is approved by the Georgia Real Estate Commission for the purpose of continuing education. No prerequisites to receive credit. I am the instructor. There's no required homework and no written exam. Students must be on time and present for all remote virtual broadcast instruction hours in order to receive credit for this course. Roll call and documentation of your real estate license number will be conducted by the chat function at the beginning and end of each session and after the break. You may only receive credit for a specific course number once every 12 months. If you've already received credit for this course, which you can't, this is the very first time we have taught it. But as McKay mentioned, later on, we will be teaching another course called 2021 GAR Contract Dissection. That has a different course number. So even though the topic is similar, you would get credit for that. So whenever you're taking any CE classes, the course number is what you can only get credit for once every 12 months, not the course topic. And you are always more than welcome to take CE classes more than once. Just if you take them within 12 months, you won't get CE credit. No recruiting for employment opportunities for any real estate brokerage firm is allowed in the class or on school premises. Report promptly any effort to recruit to either myself. There's my contact information and my direct phone number. The coordinator of the Georgia Real Estate Academy, who is Heidi Kelly. There's her email address and her phone number, or the Georgia Real Estate Commission. Heidi Kelly is going to be the one who records the CE credit. So if you guys, just quick tip, especially if you're taking any Zoom classes, have your cell phone handy. And you can always take a snapshot of the slides and then you'll have it to go back to later. So here we go, everybody. We are diving in. So the costs, Georgia Association of Realtors has a licensing agreement to use their contract forms. In 2021, if you are not a realtor, the cost is $249 for the annual use of their forms. They will be available online January 1st, 2021, and you'll be able to access them wherever you access your contract forms, whether that be through Remind Docs, through FMLS, and I know that's a loaded topic right now, or Transaction Desk in Georgia MLS. For those of you guys that have brokers that use .loop, it would be up to your broker to get those forms available through that system. You can go to the Georgia Association of Realtors website and access the forms there. Once part of the licensing agreement, once the 2021 forms are released, it is a GAR licensing violation to use GAR forms with any previous dates. Once these are out, you can only use per GAR the 2021 version of the form. You can't go back and use a form from 2020, 2019, 2018 because you feel it suits your client better. Now, the only caveat to that is you don't have to re-sign forms. So for example, if you have a listing agreement and it was signed on a 2020 GAR form, just because we roll over into a new year, the seller does not need to go back and now sign a 2021 listing agreement. Same thing with under contract, but any new forms that you initiate, whether it be a listing agreement, buyer brokerage, purchase and sale agreement, amendment, exhibit, so forth and so on, after the new forms are released, it needs to be on that 2021 form. The penalty for using forms predated at earlier versions is that GAR may revoke yours or your broker's license to use the GAR forms. So who's authorized to use them? Well, if you are a realtor, then if you are current and in good standing, meaning your local board dues have been paid, part of your dues money goes to the local level and then to the state level, which is the Georgia Association of Realtors, and part of your dues money goes to the national level, which is the National Association of Realtors. So if you are in good standing, then you get access to the GAR contract forms at no additional cost. And you access them using your NRDS number through whatever venue, your MLS system, so forth and so on. Or you can pay the Georgia Association of Realtors to become an authorized user. So you go to their website, you pay them that $249, and you will receive an FPID, which stands for Forms Purchase ID Number. Then you would use that with, in these slides, we are here in Metro Atlanta. So FMLS and Georgia MLS are the two predominant MLS services here in our area. But this course, of course, is for anybody in the state of Georgia. So whatever MLS system you are using there, however you access your forms, you would get a Forms Purchase ID number, and you would work with your local MLS system to figure out how to get the GAR forms packaged through whatever system that is. What are the alternatives? Well, if you are a co-op agent in a transaction, meaning your name is the one on the signature page, then if you have not paid GAR either by virtue of your dues money or by paying for the forms directly, the co-op agent in a transaction may share the forms with you. If your broker is an authorized user, however, your broker cannot just give you blank forms. If that would be the case, then GAR would only make money from just the brokers and not from every agent. So you can use your broker's form only if your broker's signature is on that form. If you're going to sign it and use it, you need to use the form yourself. And it does pre-print on the bottom of every form whose name has accessed the form. Just in general, there is another set of contract forms called the RE forms, and they are available in Metro Atlanta through Remind Docs, through Transaction Desk. In other parts of Georgia, I'm not sure how you access them, but they are available at no cost to Georgia real estate licensees. There is the GAR website and there is the NAR website. The Georgia Association of Realtors also has a legal helpline. You do need to be a member of GAR or a realtor in order to access that, because you only access that with your NRDS number, and the access link is through the GAR website. All right. Now, other changes. GAR changes the contract forms every year. The beginning of every year actually comes out like now at the end of every year. They do there's a forms committee that meets all year long, and they do a major or a minor. They do an overhaul of the forms based on what's going on in the market, what's going on with other agents, legal cases that have come up regarding real estate in the forms throughout Georgia. So that's when they do sort of the major overhauling. But then they always do a mid-year revision, and that usually comes out in either May or June. The mid-year revision typically is to correct any issues that were oversights in the new revision that came out annually. For example, typographical errors, number sequencing errors, grammar or punctuation errors. Every now and then, however, they will come up with a pretty substantial change to a form that does impact you as an agent utilizing these forms in a transaction. So today's CE class is going to cover both the mid-year changes, not every typographical error, but just the major changes they made in 2020, which this year they made a change May 1st, 2020. Then they had to go back and make another change to a couple of them, but especially the lead-based paint exhibit on May 22nd, 2020. So there were actually two mid-year changes in 2020. So today's class is going to cover that along with the 2021 changes to the GAR contract package forms. Now, the changes for 2021, again, I am not covering everything, or we would be here. It took the forms committee a year to do them, so we're not going to be here a whole year. I am just going to cover the major changes to predominantly the residential real estate forms that you would use in your practice. So this is a form, and you guys all have access to this wherever you access your contracts. Again, Remind Docs, Transaction Desk, Dot Loop, whatever system you're using, wherever you access your contract forms, like your purchase and sale agreements, your exhibits, your contingency exhibits, your amendments, there are also some other forms there that you should be aware of. Number one is GAR does publish this index of the changes that they made. So this is there's the 2021 revisions package changes coming out in January. You will see a whole list of the this is 2021 changes, as well as a whole index of all the special stipulations and other forms like that. So this is just in general the forms that they made mid-year, and it says this isn't the whole 2020 change package, just the ones they made in May. And again, as I mentioned, the lead-based paint exhibit, they revised, and then they revised it again towards the end of the month to be in compliance with the EPA. Changed a few minor things, but we're going to cover those. So these are the changes that they made in May 2021. And also, let me just show you guys too. I don't know if I can zoom. I don't have it here. It will say at the bottom, I'll show you when we get to another form. It will say at the bottom that no, nobody does have permission to record this session. I'm recording it and I'll post the recording later, but you cannot record it for your own purposes. So I just saw that. So thank you. It will say at the bottom the actual date. Like at the top here, it'll say, and at the bottom, it'll say if it's a revision or a January release. But anyway, for the lead-based paint exhibit, I'm going to cover this a little bit more in depth when we get to the 2021 version. But under federal law, per the EPA, this exhibit must be signed by the seller, landlord, buyer, tenant. So this is applicable if you're doing a purchase and sale agreement or a lease. And they must be, and the buyer or tenant must be provided with a copy of the lead-based paint brochure prior to that buyer or tenant entering into a binding agreement. And it has places to fill in. And again, I'm going to cover this more in depth because they made more, additional changes to 2021. So I'm not going to cover over this right now because they changed it again. Basically, the way this class works for these PowerPoint slides, I'm going to show you a picture of the form, and then the next slide discusses it. They also added not just lead-based paint, but lead-based paint hazards. So what does that mean? Well, basically, what that means is that, hang on. Right now, especially, well, I started to say, especially if you're getting ready to buy a house or sell a house, but not even in that situation. A lot of people love it too. Everybody loves watching HGTV, and everybody loves watching remodeling of homes and so forth and so on. So a lot of times we know, well, you guys type in, I need some interaction. What is the year of the house that they stopped using lead-based paint? In other words, if the house was built prior to what year, you absolutely are required to use a lead-based paint exhibit. Type in the chat, what year? Yep, you guys are correct, 1978. So if a house was built prior to 1978, you absolutely must require it. But they added not only lead-based paint exhibit, but they added the word lead-based paint hazards. So the reason they do that is back to my HGTV example. A lot of people will have a house that was built after 1978, but they model it or remodel it or decorate it with some materials that may have been painted prior to 1978. For example, reclaimed barnwood, an antique mantelpiece, shiplap that was harvested from an older property. So even though the house itself was built after 1978, there could be a situation where something in the house may have lead-based paint on it. So therefore, the exhibit and the disclosure mentions lead-based paint hazards, which would be applicable in that situation. So you must provide the buyer with a copy of not only this exhibit that they have to sign, but the lead-based paint pamphlet. And that must be done prior to entering into a binding agreement date. Now, you guys, you can get this lead-based paint pamphlet. GAR has it as CB04 lead-based paint pamphlet, or you can go directly to the EPA's website, epa.gov, and you can get all the lead-based paint information as well as the property disclosures there as well. Must be signed, the exhibit must be signed by the buyer and the seller or landlord and tenant prior to entering into a binding agreement date. And you must give the buyer a 10-day period to inspect for lead-based paint. Again, I'll touch on that a little bit more when we get to the 2021 version. Should it be attached to leases or purchase and sale agreement? Absolutely not. Well, I'll get into that in a minute. Actually, for you listing agents, if the house was built prior to 78 or there's a lead-based paint hazard in there, you guys need to make the signed exhibit signed by the seller and the lead-based paint pamphlet available to prospects. So you should make it available through by making forms available on your listings in the MLS services, have them as a pickup item in the house for showings. But absolutely, if you are a listing agent and you get a call from a buyer's agent saying that they're going to send you an offer, send in those signed forms. If you're a buyer's agent, you need to have those forms. So you need to call the listing agent and request them. But you need to do what you can. Yes, so you should attach them to the offer because it has to be executed prior to going binding. All right. Another change that the GAR Forms Committee made in 2021.
Dana?
I heard a question.
Yeah, this is McKay again. I'm sorry to keep interrupting. What about with counteroffers? Since sometimes we don't sign those exhibits when we're negotiating, does the lead-based paint still need to be signed?
Yes.
In that situation?
Yes. You guys, the EPA just did an audit of real estate transactions in Georgia. I don't know if it was all of Georgia or just the metro Atlanta area. And the fines it used to be $10,000 per missing signature and initial on the forms. I believe it has gone up. The lead-based paint exhibit needs to be signed, and you need to be able to demonstrate that the buyer or tenant received a copy of that lead-based paint pamphlet prior to going into a binding contract. In other words, it needs to be attached to any and all offers, or great point, McKay, counter offers, because it needs to be executed prior to binding. Therefore, it really should not be an amendment. Now, if you have not done it in that situation as part of the offer, as an exhibit or part of a counter offer, then yes, get yourself in compliance and do it as an amendment. But just know that the EPA states it needs to be done prior to that time frame. Great question. No, not just if 1978. Definitely if the house is built prior to 1978, or if there's a lead-based paint hazard. The house could have been built 2020, but part of the materials that they use is reclaimed barnwood from a barn that had been built and painted prior to 78. So even though the house was built prior to 78, you need to use the lead-based paint exhibit because of a hazard. Here is, again, you guys, where you can access these forms CB04, lead-based paint pamphlet, or EPA.gov. That's for the pamphlet itself. The exhibit, well, actually, you can also get the exhibit from EPA.gov or from GAR, and I'll cover that in just a minute. What if the item might have been lead-based paint not staying with the house? You guys, if you have to ask, cover your bottoms, protect yourself, protect your buyers, and protect your sellers. You need it. Your broker might have a policy on using it or not, but when in doubt, use the form. Disclose that there might be lead-based paint. The worst thing that can happen is, or the best thing that can happen is you have an additional form to sign. The worst thing that can happen is somebody or a child or a person or a pet chews on something with lead-based paint. It gets lead-based paint poison. You got a whole other world of complications at that point. New construction by the builder. Again, it depends on what materials they use. There are some brokers that require the lead-based paint exhibit. And if you guys were active in the foreclosure market, using the lead-based paint exhibit on every contract. So again, that's a broker question. Okay, we got to move on. Another 2020 mid-year change is the form F401, the all cash or no financing contingency exhibit. What they did, so a lot of times there are buyers, they're getting a loan, but they're not making the deal, the contract, contingent upon their getting the loan. In other words, you might have a buyer that they know they're going to get a loan. They've got an 800 plus credit score. They've got plenty of income. They've got a steady job, so forth and so on. But the way they're using their money is they're getting a loan. They have their own cash. They're not paying cash for the house, but they are getting a loan. They're just leveraging the lender's money to buy this house. But they're going to go under contract with a seller, not making the deal contingent upon them getting financing because they know there's not going to be an issue there, but they are getting financing. So that would be a proper use of this form. Or if they in fact are paying actual cash for the property. Or the third situation is we have buyers that are getting what's called a hard money loan, which is not from an institutional mortgage lender, but from a private lender who basically lends somebody money at a higher interest rate than they could get from a mortgage company. And usually it's a short-term loan, and it's called a hard money loan. So in mid-year 2020, GAR added that verbiage here where it says including a private hard money loan. All right, another change that the GAR Forms Committee made in May of last year has to do with the GAR F510, the closing attorney acting as holder of earnest money. Now, if you're having a closing attorney acting as the holder of the earnest money, this is the form F510 that is an exhibit to the contract. And then after the parties go binding, the closing attorney must sign an additional form called the F511, agreeing to be the holder of the earnest money. So there are two forms that go hand in hand if the parties select to have a closing attorney as the holder of the earnest money. Again, this form was changed in 2021. Shoot, did I cover that? I don't remember if I covered that in 2021. I'll have to make a note. But basically, what they did mid-year last year, it used to say that if the closing attorney was the holder of the earnest money, the only form that the earnest money could take would be by wire transfer, and that's in paragraph 5. That's how it was in January last year. Then in May, it said by wire transfer or ACH. Then in May, they took out ACH and they added that says that the form of the earnest money could be by wire transfer or by such other method as deemed acceptable and or required by the closing attorney. What was happening was we had a lot of closing attorneys that were accepting personal checks for earnest money. And by doing that, they were, number one, not reading the forms. And number two, they were putting the buyer in default by accepting a form of the earnest money that was not a wire, which is what the seller had agreed to when the parties went under contract using this form. So in May, they changed it to any other forms acceptable by the attorney. Now in 2021, I don't know, I think I did not put this in, and I apologize. They put ACH back in there. A lot of closing attorneys will not accept earnest money via ACH. The reason is it has to do with the security on their IOLTA accounts, which are their trust accounts, and the fact that the public can reverse an ACH or stop payment on an ACH, even sometimes up to 6 months. So at least in Metro Atlanta, the majority of our closing attorneys do not accept ACH as a form of trust funds. But my understanding is that closing attorneys throughout the state of Georgia do accept ACH, which is why GAR had it in there, took it out, and then put it back in there for 2021. Just a note on this form, you absolutely must name an alternate holder because if the closing attorney does not agree, you need a holder of the earnest money. Do not leave that blank, and it must be the listing broker or the selling broker. Yes, additionally, there are, even if there is a closing attorney that does accept earnest money via ACH, a lot of times there is a dollar limit amount on what they will accept. Not only that, there is a dollar limit amount that some closing attorneys will or will not agree to be the holder of the earnest money. So before you guys, the buyer and the seller negotiate to have the closing attorney as the holder of the earnest money, you need to check with the closing attorney to make sure that they are willing to do that. If not, there are forms, the GAR F511, which they would sign. If they don't sign that or don't sign that per the timeframes in that form, then the alternate holder becomes the holder. So that's why you must identify that. All right, continuing on with the mid-year changes. GAR changed the sale or lease contingency exhibit. This was pretty radically revised again in 2021. So I'm going to cover that more when we get to that in this presentation for 2021 changes. All right, that was just about it for the mid-year changes. So nothing drastic. The biggest thing was really the form of the earnest money and the attorney as holder of exhibit. Okay, here we go. Buckle up, babies. Really, actually, I don't even know why I say that. There's not a whole lot of changes for this year. The biggest changes have to do with the brokerage agreements. The consumer brochures, just a few changes. Purchase and sale, you guys, very, very few changes. Hardly anything. New construction, a few changes. Commercial, a few changes. And a few changes to the exhibits and amendments. I do have a list of the changes for new construction and commercial at the end of this presentation, but I'm not going to go over those changes in depth per this class. Also, nothing changed with respect to the, nothing substantial changed with respect to any of the financing contingency exhibits. Some of the terminology and so forth and so on, but nothing substantial regarding how it actually content-wise for the buyers and the sellers. All right, a few new forms this year. First new form, F289, request for confirmation of presentation of the offer or counteroffer. First, you're like, woohoo, awesome. Wait till we get to that form. We'll have a good discussion about that. Another interesting / exciting / interesting new form, F290, agreement to reinstate the contract. We'll have another good discussion about that. Another form, F302, new form, seller's disclosure of latent defects and fixtures checklist. Well, how does this differ from the property disclosure form? We'll address that further on in the presentation. And for the lead-based paint exhibit, GAR separated it out. So now there is the lead-based paint exhibit for purchase and sale transactions, and then a separate lead-based paint exhibit, which is same information content-wise, but instead of referencing a sale and seller and buyer, it references a lease and landlord and tenant. So they just teased that out to make a separate form for leases and the original form for purchase and sales. And another new form for you commercial agents, a commercial exclusive listing for leases. Only one new special stipulation this year. Special stipulation 627, expiration of deadlines. And with this special stipulation, it's if you were to use this in your contracts, it would state all time deadlines set forth herein shall expire at blank AM or PM on that day of the deadline. So if you do not use this special stipulation in your contracts and agreements, then the deadline of whatever that is, whether that be a contingency time frame, a closing date, so forth and so on, would be 11:59 p.m. on that day. And we've had a lot of issues where a lot of sellers inadvertently defaulted on the contract because we were on the day of closing, buyer didn't close, and the closing, let's say the closing had been scheduled for 1 p.m., it didn't close. So then at 2 p.m., the seller sent over a T&R asking for the earnest money. Well, guess what? The seller just then defaulted on the contract because the buyer has, per the contract. Now, we know in practicality matters, I don't know of many closing attorneys that are going to stay until 11 p.m. at night and close a deal. So for all intents and purposes, we know it's not going to close. Nevertheless, contractually, that buyer had through 11:59 p.m. on that date of closing to be able to perform. So the fact that the seller sent over a T&R prior to 11:59 p.m. on that date of that deadline just put the seller in default, and the buyer would get to keep their earnest money. So I believe that among some, that's one reason for this special stipulation. Another reason is to give you real estate agents a life so that you can put that all time deadline set forth expire at whatever time, 6 p.m., 8 p.m., whatever, so that you guys aren't up negotiating contracts and running around like mad at 11 o'clock at night, trying to interact with the public, taking time away from yourself or your family. So that's another reason. Those are two reasons for this special stipulation. But again, without this special stipulation and the parties agreeing to it in the contract, time deadlines do expire at 11:59 p.m. And the contract goes on to state that those timeframes are Eastern time. If the Eastern time zone is in daylight savings time, then it would be daylight savings time per the Eastern time zone. If we are in standard time, like we are now, then it would be standard time. And this class right now is actually December 9th, 2020. All right. I am going to cover pretty extensively the changes in the brokerage engagements. I'm going to go way in depth over the selling brokerage agreement. This is where the most changes occur. Like GAR does, any major changes they make universally across similar forms. So I'm just going to cover the exclusive seller brokerage agreement, but these changes are also going to be consistent with the non-exclusive seller brokerage agreement. And you'll see some of the changes in terminology are consistent across all forms. But here we go. This is going to be the majority of the class because these are where the majority of the changes occur. So the first thing that they changed is under the list price and listing period, we have a starting date and we have a new date, a marketing commencement date. So it says the price, which you put the list price. Oh, actually, let me back up. I don't have it. Shoot. The first thing they did is they changed the title of the form. They changed it from exclusive listing agreement to seller brokerage agreement. And you will see, I'll go ahead and mention it now because the terms are consistent throughout the contracts. Everybody seemed to have gotten confused by the terms that we conventionally use here in Georgia to refer to the listing side of a contract or a transaction and the selling side. Which side is the seller side? Which side is the buyer side? And it definitely got a bit confusing because we were talking about the listing side. That was pretty obvious, but every time we use the term selling side, it really referred to the buyer side of a transaction. But when we called it the selling side, there was confusion if we were talking about the seller or the buyer. So in 2021, GAR has corrected that issue consistently throughout all the forms. So the brokerage engagement and the agent representing the seller is now referred to as the seller brokerage or the seller's broker. The side working with the buyer is no longer referred to as the selling side. I'm using my air quotes, you can't see me, but is now referred to as the buyer brokerage or the buyer side. So that just eliminates the confusion, not only among licensees, but also among the public. So that was the first change, is the change in the title. Now, this change is regarding, they added a marketing commencement date along with a starting date. So hang on, I'm making notes. Okay. So it says shall begin, the term of this agreement, meaning the actual brokerage agreement, shall begin on whatever date and made available to the public made available to the public on the date of blank, marketing commencement date, and shall continue through the ending date. Why did they make this change? So we've got two dates, one where you actually start the brokerage engagement and the other where you start the marketing. Well, yes, yep, absolutely. This change came about because of the practice in our marketplace. Number one, to stay in compliance with license law, because you need this document signed in order to interact with the seller as a client. In other words, in order to give that seller advice or use your expertise and knowledge by virtue of your real estate license with respect to them selling the house. You could not do that unless they had signed a brokerage agreement, which creates the client relationship. So what was happening is you would begin your consultation or interaction with the seller and you wanted to get that listing. So you wanted to advise them, so forth and so on, but they weren't quite ready to put the house on the market. They had repairs to do. They had other things they had to take care of. It could have been due to the time of the year, the holidays, or spring break, or summer break, or for whatever reason, their children staying at home, whatever. So they weren't quite ready to actually expose it to the market yet. So great segue, Wayne. How does this impact coming soon? You will see. Can you put to be determined marketing commencement date? No, you guys, you need to fill in the blanks with specifics. If you are starting the marketing at the time you sign the listing agreement, then that date will be the same. But what happened was a lot of agents were a couple things. One is they would talk to the seller and the seller says, well, I've got to fix this, this, and this. So I don't want it to go on the market yet. Well, if you signed a listing agreement, the terms of the listing agreement, as well as the terms of the MLS systems, mandated that you put it in the MLS system within so many hours of that signature on that document. But the seller wasn't ready. So, well, don't sign it. Well, no, I'm not going to encourage my agents to not sign a brokerage agreement when the seller or buyer is, in this situation, seller is willing to sign it. Because if they don't sign it and somebody else comes through and buys the house, or another agent comes through and gets the listing, my agent and my brokerage is out. So you absolutely want to get the public to sign a brokerage engagement when they're ready to sign it. but we had to account for the fact that they weren't actually ready to expose it to the market. So that was one reason. And the other reason is for this coming soon status. So let's talk about this. Well, MLS listings, first of all, FMLS changed their rule. NAR, let me back up even further. NAR had created in 2020 a rule, NAR Clear Cooperation 8.0. And so FMLS, in conjunction or to comply with the NAR rule, added Rule 3.1, listings of properties. All improved and unimproved real estate listed for sale under an exclusive right to sell contract with a principal member of the FMLS service must be listed with FMLS and entered into the FMLS database within 48 hours after the listing is signed by the owner, except weekends, holidays. With, see the exceptions. The exceptions are if the property is outside a compulsory area or if it's a commercial listing. Then they added, within 1 business day of marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other MLS participants. Public marketing includes, but is not limited to, flyers displayed in windows, yard signs, digital marketing on public-facing websites. That would also include Facebook, YouTube, Instagram, Twitter, brokerage websites, including any IDX or VOW interactions, digital communications, multi-brokerage listing sharing networks, and applications available to the general public. Georgia MLS in kind did the same thing. So Georgia MLS's listing policies say, excuse me, all residential listings must be entered into the system within 2 business days. Any exclusive right to sell residential listing, i.e. single family detached or single family attached or multifamily, is required to be entered into the listing database within 48 hours after obtaining the necessary signatures. Other types of exclusive listings, commercial, land, so forth and so on, are optional, but must be maintained according to Georgia MLS's policy once they are entered. The dates must be supported by the listing agreement. Any change to the listing must be reflected in the system within 1 business day. Any change to the original listing agreement, list price, or status must be reflected within 24 hours of the broker's receipt of the seller's authorization. All listing content must be accurate and timely made. So here's what NAR says. I guess I should move this slide sooner. The NAR Clear Cooperation 8.0 states, and this is why the MLS systems, and again, I'm just familiar with FMLS and Georgia MLS. I imagine it is all the MLS systems actually throughout the country that made these changes to comply with NAR. Within 1 business day of marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other MLS participants. Public marketing includes, but is not limited to, flyers displayed in windows, yard signs, digital marketing. Same verbiage. FMLS used this verbiage verbatim from NAR. For more information, you guys can, there is a link to the NAR policy about clear cooperation. So that brings us to coming soon. And FMLS and Georgia MLS now have a new coming soon status. And they have done that to be able to cooperate, to comply with NAR so that you can enter it into the MLS system within that time frame. But it's not actually being marketed to the public per your client's request to not actually show the property yet. So that's what brought about the birth of the coming soon status. So for coming soon, a seller must sign a brokerage agreement and the property must actually get listed. And what that means is if for some reason you sign a brokerage agreement, it's going to be a coming soon listing. For whatever reason, you get a contract, the seller agrees to go under contract with the buyer prior to it actually going live, so to speak, within an MLS service. That does not alleviate your agent or broker obligation to actually list the property in the MLS. So it still must be listed. It may not be shown to any prospects until it is available to all. You cannot show it to your own clients. You cannot show it to any sign calls. You cannot show it to any buyers within your office. You cannot show it to any prospects during this coming soon period. And if you do, not only is it a violation of the coming soon parameters, but it is also a potential fair housing violation that you only showed it to a certain select buyer prospect, and it could be argued that buyer prospect was shown to it, that it was discriminatory who you did not show it to. So you guys, you need to be extremely careful. Coming soon is not a free look for you as the listing agent to get a sign call, a head start. It's not a free look to just agents in your office. It cannot be shown to any prospects during the coming soon status. A coming soon listing refers to a property that is not available for showing until a later date. Coming soon can be a legitimate advertising technique, allowing the owners more time, as again, to complete repairs, pack, or otherwise prepare the property for showing or sale. A legitimate coming soon listing should truly be unavailable for purchase or showing. If a coming soon never gets listed, that is a license law violation, potentially, but most likely. That is an MLS membership violation, at least for FMLS and Georgia MLS. And as I mentioned, it could be a fair housing violation. So you guys, you can't use this coming soon status as a quote unquote head start. And it also may be construed as a realtor code of ethics violation. Sometimes coming soon advertising is used to circumvent the MLS, market the property to a select group of people, or pressure a buyer to use a listing broker for the transaction, which breaches, again, all of these potential things above. The proper use of coming soon, you must have a signed seller brokerage agreement. That is per license law, GREC Rule 520-1-.002. Avoid violation of GREC license law by misleading advertising. Because if you have it coming soon, but it never gets listed, guess what? You have just misled the public in your advertising. And also another license law violation by putting a sign on the property and offering it for sale without the written consent of the owner or authorized agent. Additionally, you guys, you may have appraisal issues. If a property is sold prior to being exposed on the open market via an MLS service, the appraiser could put downward pressure on the price, stating that it was not properly, it wasn't exposed to the open market. Therefore, you had a buyer that was going to buy that house and pay whatever amount for it. For example, let's say you have a family that lives in a neighborhood and they learn that the house across the street from them, that is one level ranch, is coming soon on the market. Well, they have a parent that they are going to move, and this house would be ideal. The family can keep their eyes on that parent, so forth and so on. It fits their needs. Well, that parent might be willing to pay more money for that house because of other circumstances that makes that house perfect for them. And that's not that property being exposed on the open market for price reasons. So you may have some appraisal issues. All right. If a broker is a member of an MLS, again, you need to check with the MLS rules. The FMLS rules regarding their coming soon status is the property is currently off market and will be active within the next 21 days. It is a max time frame of 21 days. So you would list it in, if you sign it today, it must be listed in FMLS within 48 hours, but you would list it in the coming soon status, and it has to go quote unquote live or marketed to the public within the next 21 days. Only FMLS members will be able to view coming soon listings on the MLS service. The coming soon status is only available at the beginning of the listing period, and once it is taken out of the coming soon status, it can't go back as coming soon. Does this mean that you can bypass an agent and list on the FMLS without ever hitting the market? No. Again, you must have an exclusive listing agreement signed with a licensed FMLS member real estate agent to take advantage of this perk. If you sell a home before it goes live, you are still responsible for FMLS fees and other agreed signed upon terms. Georgia MLS has the same rules, maximum of 21 days, that it can be in coming soon status. This coming soon status does not add to your days on market time frame. It does have its own special label, CS for coming soon, and cannot be distributed to a broker or agent or any listings in the coming soon status will not be distributed to any consumer facing websites or third-party syndications. That's like Zillow, Trulia, Realtor.com, Redfin, so forth and so on. Listings in coming soon cannot be shown. It is just for other MLS members. And again, this is in compliance with the NAR. And I know not all agents that are members of, not all brokers that are members of FMLS and Georgia MLS are realtors, but that is why these changes came about. All right. What are the benefits of a coming soon listing? Well, yep, it does allow the seller to make repairs, get themselves ready, again, based on the timing of the year, holidays or vacations, and it gives the listing agent more opportunity to get sign calls. They can't see the property, but you can garner excitement. It also gives, I need to add this, it also gives the listing agent more benefit to get your marketing together. Perhaps you're going to take professional photos or drone photos. It gives you time to get those things checked out. Drawbacks. The drawbacks are the buyers want to see that property, especially in this market we are experiencing right now. We have very, very limited inventory and more buyers than we have property. So we have buyers that want to see properties now and sooner than now, but they cannot see it. So you are potentially putting yourself or your colleagues in an untenable position when they drive by and they see a coming soon sign or a listing sign in the yard, but then they can't go see it. And it does have limited exposure on the market, so potentially fewer offers and potentially lower sale price. Again, it puts agents, other agents, your colleagues, in a position where they're not knowledgeable about the market. If it's not, if they don't see the information as a coming soon listing in the MLS service, and your listing broker commission might not be protected if you don't actually have the seller brokerage agreement signed. And again, I'm repeating myself now, it could be a fair housing violation if not exposed equally to all groups, and again, might not appraise. All right. Can you accept an offer? It cannot be, I would say, let me go back. Honestly, you guys, I don't know why y'all are using coming soon listings right now. Well, I take it back. You are using them if the seller has repairs and so forth that they need to do. And you definitely want to get that signed. Can the seller accept an offer? Yeah, the seller can always accept an offer, but the problem is the seller going to want to accept that offer? Number one, the buyer can't see the property, so it's a sight unseen offer. Number two, the seller could potentially get more money once it gets actually exposed in the open marketplace. And again, you as the seller could be charged with a violation of federal or state fair housing laws, and you as an agent run the risk of being potentially charged with a violation of license law, violation of Realtor Code of Ethics, or fair housing. All right. If the amount of work is going to take more than 21 days, then either don't take the listing or take the listing, have it go live, and then account for those repair issues once the listing is live. All right, moving along. Changes again, we're back on the exclusive seller brokerage agreement. The commission changed. So the commission change, let me show you what it looks like. This is paragraph C. Okay. All right. Paragraph A4 changed the commission verbiage. Why am I getting so confused? Hang on one second. Let me do something. Give me 1 second. Okay. Can you guys see this? Yes. Let me make this a little bit bigger. The commission changed in that it states seller agrees to pay broker the following commission. Oh, here's the change. It just says at the closing of any contract to sell. It used to say contract. They cleared up that, and now it says contract to sell. Because contract was ambiguous. At the closing of any contract. Well, what does that mean? This listing agreement is a contract, or a contract for a purchase and sale, or what about a contract to lease, so forth and so on. So they changed that verbiage to contract to sell. There we go. I have it right here. Change from seller agrees to pay broker at closing to seller agrees to pay the following commission closing of any contract to sell of the property. And they have added 2 new paragraphs: commission adjustment to cooperating broker and separate lease on commission. Separate commission lease. You guys are going to like this next one. They've added this paragraph C. This is paragraph AC. And what it says is commission adjustment to cooperating broker. There may be circumstances where the seller's broker, again, see, instead of it saying listing broker, it now says seller's broker. Seller's broker shall not pay the cooperating commission referenced in section A4B above. These circumstances and the commission that shall be paid in such circumstances are as follows. So this is to account for everything that you guys have seen in the private remarks section of your MLS listings. The listing broker may change the commission offered to the co-op broker, typically based on certain circumstances, but you would have to disclose what those certain circumstances are here in the listing agreement. In other words, the seller must approve what happens to their money. So for example, you guys have all seen in the MLS remarks, it says selling broker commission to be X% if the listing broker shows the buyer, right? You guys have all seen that. So that would have to be clearly identified and agreed to by the seller in the listing agreement. And savvy listing brokers were already addressing that issue as a special stipulation in your listing agreements, but GAR has just added it in 2021 to the actual listing agreement itself to account for that, so that it is backed up what the listing broker is offering the buyer's broker. If you are changing, if there is an opportunity for the commission to be changed, you absolutely must mark yes under VRC. VRC stands for variable rate commission in your MLS listing. I encourage you guys to mark yes to VRC on every listing, because there are certain circumstances where that commission rate to a co-op broker might change based on the negotiations throughout the deal. So basically, there is a field on every listing where it has selling commission, and that notifies the selling broker or the buyer's broker what to expect if they participate in a sale of that listing. If there is a possibility that the selling commission might be different than what is listed in the selling commission field for any reason, again, whether that's something in advance, like you tell your seller, look, if I get both sides of the deal, your total commission paid would be X rather than Y. Or if I show a buyer and they're working with another broker, the commission that's going to be paid to that co-op broker is X versus Y. Or as I mentioned, throughout the course of negotiating the deal, to make the deal work, I'm going to change my commission and lower my commission to this or whatever. An explanation must be provided in the private remarks, and you must mark yes under variable rate commission. It also, well, I just went over that. All right. And any changes to the variable rate commission, any explanation would be marked in private remarks. Can a buyer's agent request or see the listing broker's agreement? Absolutely. You can ask for anything you want. Listing brokers, are you obligated to show another broker your client confidential file? Absolutely not. But if it goes further than just a broker to broker discussion, i.e. if it goes to court or arbitration, it better be backed up in that listing agreement. So yes, buyer's agents can absolutely ask for the listing agreement. Listing agents, you do not have to share that because that is a client confidential contract signed between you and your seller. And you should not necessarily be showing that, but it better be in there. And if you guys are having these issues, you should get your brokers involved, and your brokers should check with the agreement and affirm, yes, it is in there. And broker to broker confirmation of that should hold up to the truth. All right. GAR has also added in 2021 a new section, paragraph A4D, separate commission on a lease. And basically what this states is if the seller leases the property or enters into a lease purchase agreement or a lease with an option to purchase, the seller shall also pay the broker a separate leasing commission in the amount of X amount of dollars and as follows. And that would be something like within 24 hours of the binding lease agreement or something like that. Notwithstanding any provision of the contrary contained herein, the payment of a leasing commission, including a lease purchase or lease with an option to purchase, shall not relieve the seller from paying a commission at the closing of a contract to sell as provided elsewhere in this agreement. So sometimes you'll have a seller that puts the house up for sale. For whatever reason, they don't sell it, but they're willing to accept a lease or a lease purchase. Well, you as the agent, you would want to get paid for your valuable services rendered at that time. So instead of having to make that an amendment to your brokerage agreement, GAR has kindly included that in the actual listing agreement itself. Is using seller broker instead of buyer's broker correct in the commission change? Again, to be consistent with the forms in 2021, you should use the broker working with the buyer as buyer's broker. You agents, those of us who have been practicing over 25 years, that's going to be a hard change. We're so used to referring to the brokers as the listing broker and the selling broker referring to the buyer side. But it does get confusing for newer licensees, even some experienced licensees, and it's very confusing for the public. So to be consistent when referring to the broker working with the seller, you should call them, and I'm even doing it in this class because of habit. Over 25 years is a hard habit to break. But the broker working with the seller should be referred to as the seller's broker, and the broker working with the buyer should be referred to as the buyer's broker. All right, moving along, another change in the agency section. Under the dual agency section, they have added even more. Dual agency is legal as long as it is agreed to by the parties with consent and written consent and explained. Apparently, the way the contracts read prior to 2021, the dual agency section really had implied consent rather than informed consent. So you will see throughout universal changes throughout all of the GAR contracts, when it talks about dual agency, whether it be listing agreements, buyer brokerage agreements, leases, purchase and sale agreements, commercial, so forth and so on. Anytime it talks about agency and dual agency, this change has been made. So it first talks about what types of agency relationships not offered by the broker. That's not a change. What they did add, again, this is the listing agreement. So it says the seller does or does not consent to the broker acting in a dual agency capacity, as that agency relationship is explained in section B6 and in the ABCs of Agency Consumer Brochure. Seller expressly consents to the broker acting in other agencies. So again, they just had to spell this out to make sure that the parties were giving informed consent rather than implied consent. In 2020, it did not have that. And I just went over that. Now, also in 2021, they removed paragraph A7, employee or independent contractor. That was the section that said the agent is an employee or independent contractor of the broker. They just deleted that paragraph there. And you'll see they added it in later on in the other section. Okay, moving along to the corresponding paragraphs, paragraph B. Where it talks about exclusive right to sell under this paragraph. They have added the verbiage that the seller has not unilaterally terminated a previous listing. So basically what it says, it has always said that the seller is not a party to any other exclusive seller brokerage agreement, and all such previous agreements have expired and not been renewed. This is what they've added. Seller acknowledges that the seller may have to pay a previous broker a real estate commission if the seller is subject to a current seller brokerage agreement or has terminated a previous seller brokerage engagement without the consent of the previous broker. In other words, a unilateral termination of the seller brokerage agreement is a default. And if you have a seller that says, I fired my previous agent or broker, what on earth does that mean? If it was not a mutual termination done in writing and signed by the broker and the seller, they could still owe that previous broker a commission. And that's always been the case. They have just put it in writing for clarification for sellers. You'll see they did the same thing in the buyer brokerage agreement. Exclusive under the list price and period. Again, this is wonderful. Look at this, you guys. List price, because again, on the fill in the blank, we put in the list price. Then it says seller agrees to list the price of the property for sale. Failure of the property to be shown or sell at this price may be an indication that the list price of the property is too high. I love it. Don't you guys love that? Therefore, that quote unquote bad news doesn't have to come from you. It's actually written in the contract that they signed. And then in paragraph 2B, to be or not to be, it does talk about the initial period when the property is under contract, the same as 2020. So basically what that says is if the listing agreement expires, let's say the listing agreement expires today, December 9th, 2020, but we're already under contract and our closing is going to occur on December 30th. Even though the listing agreement by what was printed on here had expired, it remains intact through the closing of the contract. All right, and then extension. This has been changed a little bit. And basically what this is, paragraph 2BC, basically what this means is, let's say you have a listing and let's say you get a contract on it and the seller is under contract for 8 days and the buyer terminates within their due diligence period, but the property was off the market for those 8 days. Your listing agreement automatically gets extended unilaterally by the broker for that time frame that we were off the market, when we were binding and under contract, but that contract didn't close. So we get to add an additional. So instead of our listing agreement expiring today, 12/9, we get to add those 8 days. So 1, 2, 3, 4, 5, 6, 7. Now our listing agreement would automatically extend to December 17th. But by automatically, it's or unilaterally, the seller doesn't have to agree to it. The seller agrees to it when they sign this listing agreement, but it's not automatic. The broker must send notice to the seller that this listing agreement is being extended for those 8 days under which we were binding with a contract that failed to close. You must send that notice of that extension within 5 days from when that contract terminated, and no later than the event of the expiration. So let's say we were under contract back in October, the contract terminated, we were under contract for 8 days and the contract terminated October 20th. By October 25th, we have to send the notice that our listing agreement is being extended till December 17th. And if the broker does not send that notification of the extension, then you don't get that automatic extension. It's waived by the broker. So what they added this year was that 5-day time frame. And just as a note, there is the GAR form F158, notice to extend the brokerage agreement. That would be the notice form that you would use. All right. And with that notice, this GAR F158, they have just changed the title. It used to say notice to extend listing agreement. Now it just says brokerage engagement. So it is a multi-use form to use with either the buyer or with either seller or buyer brokerage agreements. All right. Moving along, another section that GAR has made is under the section paragraph B3, where it talks about marketing and the photos and videos. It does say the seller acknowledges that the buyers and other brokers may take photos, videos, and other technology to capture images of the property to assist in marketing of the property and helping buyers remember different properties. Seller agrees to remove any personal property items to the listing of which they don't want remain. So when a seller signs a listing agreement with a listing broker, they agree that the listing broker can market the property with signs and images and put it out on the internet in MLS services, so forth and so on. The seller does not necessarily agree that a buyer can when a buyer is seeing their property, take pictures and put it on Facebook and say, hey, this is the house I'm thinking about buying. What do you think? Nevertheless, unfortunately, that occurs. So this is just a reminder in the listing agreement that buyers and selling brokers, you selling brokers don't do that. You brokers working with buyers don't do that without the seller's written permission. But sometimes buyers will do that. So this is just an acknowledgement that guess what? Sometimes it happens. You need to be made aware that that happens, and don't remove anything that you don't want out there. Additionally, when the section paragraph B3B, where it talks about the property going in any of the MLS services within one business day, what they've changed is they made a reference to the change of the listing agreement, the client brokerage agreement date versus the marketing commencement date. So now it states the broker agrees to file this agreement with the above referenced MLS service within one business day of the marketing commencement date, which shall be the date the property is made available to the public. So what that means, back to our earlier discussion, is you listing agents, you can sign a seller brokerage agreement and not, so that goes back to that 21-day question. If the you can sign a brokerage agreement with them now. If they have repair issues that are going to take longer than 21 days, this new verbiage I'm hesitating right here. This new verbiage basically says it does not need to go into the MLS system until 1 day within the marketing commencement date. So you're not required to use that coming soon status in an MLS service. And some MLSs may not have that coming soon status. So we'll see how this plays out with some of the MLS services. But in the listing agreement itself, that would be an exact situation for that. You do want to go ahead and get the seller to engage in a client relationship with you and your broker, but not put it available to the public until, let's say, 30 days. But once it goes live with the public, reference to that marketing commencement date in paragraph A, it does need to go in the MLS service within 1 business day after that. All right, now moving along the commission paragraph, they have just changed some of the titles where it says obligation to pay commission. And again, it talks about the sharing of broker's commission with a cooperating broker. We talked about that with the fill in the blank, and it basically says there may be times when the broker may not pay the cooperating broker the full amount of commission. And that would be, as we've already discussed, if I show your buyer, if it's listed in the private remarks, if I show your buyer the selling commission to be X%, best practice, have this discussion with the seller and together decide on whatever percent or fee you are going to offer a co-op broker. And again, mark yes to the variable rate commission. Under this paragraph B4 under commission, it used to have what happens to commission if the seller defaulted. That all got rearranged and moved to paragraph C8. All right, moving along, the protection period. Going the wrong way. The protection period on a contract was completely reworded for clarity for sellers and agents. There are a lot of agents that missed what the protection period is. So basically what it states, let me see if I have this on the next slide. The seller, all of this that I have underlined is what I'm going to talk about on this next slide. The seller owes the broker a commission if the seller sells or leases or options, so forth, so on, the property to a buyer whom during the time of the listing agreement, the broker or agent brought to that buyer's attention. And it does say either in person or virtually. Either in person or virtually. Then it says the protection period begins at the expiration of this agreement, or if the seller unilaterally terminates the agreement, then let's say our listing agreement expired today, December 9th. That was what was written. But let's say they actually unilaterally terminated the contract on November 30th. Well, they terminated the listing agreement 9 days short of it. So I get to add my protection period is increased by 9 days. So the number of days that were left on the original agreement gets added to the protection time frame for broker commission. However, there is no protection for commission for the broker if the listing agreement is mutually terminated early. And there is no protection for commission if the seller lists the property with another broker via an exclusive seller listing agreement. The only exception to this is if the seller had unilaterally terminated this one. Let me show you. This is what agents missed repeatedly. Let's say you have a listing and we're expiring today. We expired today, December 9th at 11:59 p.m. at night. We have a buyer's agent that shows the property. They showed it yesterday, and you call up that agent. And you're like, well, did your buyers like the property? Yeah, they liked it. They're deciding between yours and another one. You call them today because you know your listing agreement expires tonight at 11:59. What do your buyers think? What can I do to help them write an offer? They're still trying to decide. The buyer's agent says they're still trying to decide. I'm not sure. I'm not sure. Today comes and goes. It is now tomorrow. It is now December 10th, 2020. Our listing agreement expired today, 12/9 at 11:59 p.m. Let's say we had a 90-day protection period, but the sellers also knew that we were expiring. They met with a new listing broker. They signed an exclusive seller brokerage agreement with listing broker number 2 to begin 12/10/20. So now it's tomorrow, 12/10/20. Guess what we get? We get the offer from the buyer's agent that showed the property yesterday before we had expired. Do we get that commission? Our listing agreement has expired. We have a protection period of 90 days. We get an offer the day after expiration from the buyer's agent that showed the property prior to the expiration of this listing agreement. But the seller has signed a new listing agreement with listing broker number 2, and the date of that starts 12/10, and that's the date we get the offer. Do we get the commission?
No.
You guys type your answers in the chat, please. I see a lot of yeses, a lot of no's. No, no, no. Your commission is not protected. This is what you guys miss all the time in this protection period under the listing agreement. It states, no commission shall be due if the seller enters into a contract during the protected period buyer through another licensed broker with whom the seller has signed an exclusive seller brokerage engagement agreement. You unfortunately now have to give that offer to listing broker number 2. Now, could you work out a referral fee with them? Perhaps, but that you are not protected. The protection period ends the moment the seller lists an exclusive seller brokerage agreement with another broker. The only exception is if the seller had quote unquote fired you or unilaterally terminated this brokerage agreement and then signs with another broker, then yes, you are still entitled to pursue them for that commission. Procuring cause of sale. You're not the procuring cause of sale necessarily. It would be the listing broker number 2. The contract would close between that buyer's broker and listing broker number 2. Your commission would be protected, not protected by if it had just during the protection period. And because you agreed to that when you signed this listing agreement, it says that the no commission is due. There's no protection if they signed an exclusive seller brokerage. You had however many days to sell the property. Guess what? You didn't get it sold during that time frame. So the only exception would be if the listing agreement had been unilaterally terminated. So yeah, should you extend that listing? Yeah, but you need to have extended it before they signed a listing agreement with another broker. So, yep, interesting. So they tried to clarify that. Apparently, still not quite clear enough. All right, moving a special stip. No, not the special stipulation. Doesn't necessarily protect you. You don't need a special stip. It's spelled out there. You would have to get an extension. And the reason the special stipulation wouldn't protect you is because listing broker number 2 is not privy to your contract and they're not a party to your listing contract. So the listing broker number 2, if the seller signs an agreement with them, they're not a party to your listing agreement. In other words, you guys be really careful when you're interacting with the public. It's a little bit easier there's some license law around this too, but we don't have time to go into that. But be really careful when the public comes to you and you ask them if they're working with another broker. If they say, no, not anymore, or I fired them, that doesn't necessarily mean that that public person does not still potentially owe that previous broker money. You can be fired from representation, but not necessarily compensation. Number one. And number two, it could be potential license law violation for you to continue to work with the public without checking with their previous broker if in fact that brokerage agreement has been terminated. Again, we discussed that in license law class. Okay, moving along. Under the agency situation, the agency B6, the agency brokerage paragraph. Again, this is just disclosure to imply that the seller now gives informed consent versus implied consent to dual agency, should that be the case. And again, it does have in paragraph 6B6D, no adverse agency relationships. Again, more confirmation regarding the disclosure. Unless specified herein, broker has no known agency relationships with other parties which would conflict with the interests of the seller. And negotiation. This is a new paragraph regarding negotiation. Because remember, it used to say the seller does or does not allow the broker to assist with negotiation. Under the paragraph B, the explanatory paragraph, it does say while the broker may assist in negotiating the terms of the contract, if the seller has elected to have a broker assist in this role, all decisions regarding price, terms, and other conditions in a contract to sell shall still be made by the seller. This, even though you as the agent are assisting in the negotiations, final decisions are the sellers. The seller cannot come back and blame you. They may, but they don't have any contractual grounds to blame you for anything in a contract. All right, moving along to other terms. Woo, I got to go faster. It does now reference under the property disclosure statement. We now have a reference to the law. We've always bandied about the term. It's the seller's property to disclose latent material defects of the property of which they have knowledge. We have used that verbiage, that term in describing stuff to sellers for years, but it was very, very difficult to find that section in our Georgia official code, Georgia annotated. It is now referenced here because it is under the tort section. It is not under the contract or the trade section. So thank you to Christina Chow for referencing this in the actual contract. It is Georgia state law, OCGA, Title 51, Chapter 6.2, that requires a seller to disclose latent defects in the property which could not be observed by a buyer upon reasonable inspection of the property. So it does reference the law. A seller is required to disclose these even if selling it as is. It also references this new form, which I'll get to in just a second, F302, disclosure of latent defects and fixtures checklist, as well as requirements of disclosing any lead-based paint using those exhibits that we've already discussed, and providing those to the buyer, to any buyer, the lead-based paint brochure and exhibit any buyers interested in the properties. Now, it also has added a couple of things. Number one, the lead-based paint disclosure and the seller's property disclosures need to be updated through closing should any changes occur. That word through closing is a change. This is the new form F302, seller's disclosure of latent defects and fixtures checklist. It is only a 2-page document. And this is what it looks like. This fixtures checklist section from the bottom part of page 1 and page 2 is exactly the same as the fixtures checklist on the seller's property disclosure statement exhibit. This is just short and sweet. And basically, what was happening is we had a lot of sellers or owners who never occupied the property, whether they be an estate, a foreclosure, investor, so forth and so on. And so a lot of those owners would not fill out the seller's property disclosure form. But guess what? It was still incumbent upon them, per the fraud and deceit law under the tort section of our Georgia Code, OCGA 51-6-2, that they were required to disclose a material defect with the property, even if selling it as is. But they refused to sign those forms. So GAR came up with this short and sweet form that is just a disclosure of latent defects. Here's where they fill it out right there. And then there was also some question about what fixtures were staying with the property or not. So brand new form. I think you guys will enjoy being able to use this form with your sellers who are not owner occupants to help them and you comply with the law. So here's what the law says. Basically, misrepresentation of a material fact is actionable as deceit if they conceal it, or if they concealment would be if they fail to disclose it by not making representation of that. In other words, this is just the law that supports that they must disclose latent material defects. Now, in the actual seller's property disclosure form, the only couple minor changes to that. Number one is they have added, has any part of the HVAC system been replaced? Date of the last service, and is any heated and cooled portion of the main dwelling not served by central heat and cool? They have also added a fill in the blank for the age of the water heater. And the only other thing they changed in the existing F301 seller's property disclosure statement is under the termite section, they've added, it used to just say, is there any damage from animals, squirrels, mice, possum, insects, blah, blah, blah. They've added, or hazardous condition resulting from such animal intrusion. You guys, I'm going to finish up with the listing agreement, then we'll take a break. All right, just a little bit more about disclosures. Sellers in Georgia do not need to disclose certain things that have happened to the property. For example, you don't need to tell a buyer if a diseased person ever lived in the home, homicide, felony, suicide, so forth and so on. We in real estate refer to that as a stigmatized property. That is based on Georgia law, OCGA, Title 44, Chapter 1, 16A1. Additionally, a seller in Georgia is not required to ever let a buyer know if a registered sex offender lives in the area. There's the quote, the citation to the law on that. There is an admonition in the purchase and sale agreements and in all the buyer documents for the buyer to check that out for themselves. And however, it does state that the seller must answer any direct question the buyer asks about these things. That's the citation for the law of that. And there is the law on that. Just another slide. The answer is as a listing broker. So that's what the seller must do. Now, what about as a listing broker? Are you required to disclose that? No, unless you are asked point blank. If you have knowledge of it and you're asked point blank, then you must answer truthfully. The only protection is a disclosure of aids, is confidential information. So if a owner of the property has or passed away from AIDS, even if asked point blank, not only do you not have to disclose it, it is illegal for you to disclose that information. Now, the seller can disclose that him or herself, but as an agent, you may not. However, you as a licensee, per license law, brokerage relationships, if you have knowledge of any adverse material facts pertaining to the physical condition of the property or the improvements, you are obligated to disclose that. Now, you don't have to go discover those, but you are obligated to disclose not only adverse physical conditions of the property and improvements, but within physical conditions in the immediate neighborhood within 1 mile of the property that you actually know. So what that means is if a seller has knowledge of a latent material defect, and they tell you, and they say, shh, don't tell, I'm going to cover it up. By virtue of you having a license, per license law, you must disclose that because now you have knowledge of that. So you can't keep your seller's secrets of material defects of the property or the neighborhood. Not only is it a license law violation for you to withhold that information, if you are a realtor, it is also addressed in the Realtor Code of Ethics, Article 2. All right, lead-based paint disclosure. You guys, we've had a pretty thorough discussion about that regarding when we talked about the changes they made in 2020. Here's just a slide regarding the GAR form lead-based paint pamphlet is CB04. Also, I strongly suggest you use the consumer brochure CB13, Protect Yourself When Buying a Home. That actually has now been changed to Buying Real Property. Also, you can go to the EPA.gov website, and those are the consumer informational pamphlets. And then the actual exhibits are F316, which is the lead-based paint exhibit to use for resale, for purchase and sales, resale or new construction. And 918 is the new form they created, which is the same thing, but just with respect to leases. Again, seller must sign and make these available to the buyer prior to entering into a contract. Now, there was the thing about the 10-day. The seller must allow a buyer, if desired by the buyer, a 10-day risk assessment of lead-based paint prior to entering into a contract. So this does not necessarily mean that you have to allow for a 10-day due diligence period. This means the buyer has the opportunity to inspect for lead-based paint prior to entering into a contract. Well, in this market right now, a seller might go under contract with another buyer while the buyer is using their 10 days to assess for lead-based paint. So this is the for the 2021 version, and it has a new name. Again, it just references purchase and sale. The one for leases is Form F918. It has this section up here under federal law. This exhibit must be signed by the seller and buyer, and the buyer provided with a copy of the lead-based paint brochure prior to entering into a binding agreement. It has separated it out to make the signatures and initials a little bit easier, where it talks about this is the seller's disclosure section. This is the buyer's acknowledgement. Now, this section up here, you mark under the buyer's acknowledgement, where it says, here's where it talks about the 10-day opportunity to assess risk. There's E1 or E2. This first section would be if a buyer wants to examine the property for lead-based paint prior to being obligated to purchase. So the intent of this form is a little confusing because the EPA says that it has to be done prior to entering into a binding agreement. Here in Georgia, we have a due diligence period, which is a time frame under which you're binding, but the buyer has the right to terminate under no penalty. So this form is a little confusing. It is GAR doing its best to comply with the EPA mandates, as well as our contracts that do account for a due diligence period, which not all contracts have. So, but this section right here is the buyer has the opportunity to attend 10 days to assess lead-based paint prior to being obligated to purchase the property, or, and this is mostly what we're seeing in contracts right now, waive the opportunity to do it beforehand, but that doesn't prevent the buyer from evaluating the property for lead-based paint during any due diligence or right to request repairs period. All right, and this is just a picture of the new form, exact same information. It's just with respect to leases. So the verbiage in here is tenant and landlord rather than buyer and seller. All right, moving along, under the section about exclusive, the limit on the broker's authority and responsibility, they have added a section about propensity of the property to flood and flood zone certifications. You guys, we were having a lot of contracts actually, where buyer and seller go under contract, where past due diligence has expired, financing contingency has expired, all contingencies, buyer side contingencies have expired. We're getting close to closing, and we get the preliminary HUD statement from the closing attorney, and lo and behold, there is a fee on there for that the buyer must pay for flood insurance. And they're like, what on earth? The seller never told me. Well, the seller's like, I never had to pay flood insurance. So this is, and so we were having a lot of buyers. Well, it was just creating a lot of issues at closing for an added fee that the buyer didn't want or wasn't willing or wasn't able to take on, with no information about that. Well, you guys, that is something that they need to check out during their due diligence period and choose to proceed with the contract or terminate. So under the section in the listing brokerage agreement, this also has been added. I'm talking about buyers because it's been added to the buyer brokerage and the, I believe the purchase and sale also, but they've also added to the listing agreement that a propensity for the property to flood or flood zone certifications is not a broker or agent responsibility, but it is on the public. All right, the whole C6 miscellaneous section, all the paragraphs have now been alphabetized, and they have added in and changed some of these paragraphs. So quickly, they've added a new paragraph, attorney's fees. Basically, if the buyer and the seller go to court over this contract, the loser may have to pay the winner's attorney's fees. They have added a section about broker. It states that anywhere the term broker is used in any of the issues, broker also can be used simultaneously with affiliated licensee. Isn't it the lender responsibility to check on flooding? Sometimes, for whatever reason, these flood zone issues were not discovered until it was discovered by the attorney under a title search. It wasn't discovered by the lender. It should be. If it is a good, reputable, thorough lender, the lender absolutely should see it. But it also wasn't being addressed even by the hazard insurance company prior to that. So definitely something for you buyers agents to have your buyers check out during due diligence. Okay. A new paragraph about the GAR forms. This is GAR protecting themselves. It has always said no party is required to use the GAR forms. We have a lot of other forms. No party is required to use them. You cannot force the public to use any specific form to contract for the purchase and sale or lease of real estate. Now, this is what's new. They say the courts may interpret GAR forms differently than the intention of one or more of the parties. In other words, we're doing the best we can, but the court could come to a completely different situation than what buyer, seller, and both brokers believe is the case when signing a GAR contract. It also says that the GAR forms may only be used subject to their licensing agreement. In other words, you cannot share these forms with the public or somebody that is not has a license to use them. Now, remember when I told you they took out in section A, if you are an independent contractor or an employee, they have taken that out and added that under this section C6I. They have changed the title about notices between seller and broker. And this is another wonderful, wonderful thing. As a broker, I love this. They have added a new paragraph, C60, third-party vendors. It basically states that the broker does not warrant or endorse the performance of any vendor. Names of vendors are provided merely as a courtesy to the seller. This same provision is also in the buyer brokerage agreements too, you guys. The broker providing the name and contact information of a third-party vendor is only the starting point for a seller to hire a required vendor. And then, as I mentioned, it used to be under the commission paragraph. The seller default paragraph has now been changed. So this is the 2020 version. It was paragraph C1 where it talked about seller default. And now in 2021, it is going to be under paragraph 8, under seller default. I'm sorry. This is where it talks about, let me back up. In 2020, it just was short and sweet about seller default and what the remedies were. In 2021, they have added all of that information under the seller default, but they've also added all this information that used to be paragraph C1, where it talks about commission and so forth and so on. And basically, if the seller unilaterally terminates this agreement prior to the end of the agreement without a written agreement by the broker, that constitutes default. If the, no, hang on, let me back up. This is different. This is new. This says that a termination of this agreement prior to the end of the agreement without prior written agreement by the broker. Basically, what this broker removing signs from, removing the listing from the MLS services, taking down signs, ceasing to market, shall not be evident. So basically what this means, let me go back. Basically what this means is that the unilateral termination by a seller of the exclusive seller brokerage agreement, if they've done that and you go and take your sign off, so forth and so on, that does not mean that you are agreeing. It doesn't create a mutual termination. It's just that you are taking down the marketing. Under broker remedies for default, it does say the seller's obligations to pay broker its commission shall be controlled by the protected period as defined. We've already gone over all that. And then it also says under seller default that the seller is to reimburse the broker for expenses, including MLS withdrawal fees. The issue is if you are trying to recover, this is in the event that a seller unilaterally terminates your listing agreement, that they owe you, they have the obligation to reimburse you. The issue is if they're firing you, you may have a hard time enforcing them to pay you whatever fees, out-of-pocket expenses to recover those fees. So a couple of things when you are entering into a listing agreement, point of practice, you might want to consider using the GAR form F-149 retainer fee exhibit to account for, to get the seller to pay upfront any expenses for marketing, especially if you're using high dollar professional photos or drone photography. Or you might want to add a special stipulation regarding a specified early termination fee so that these dollar amounts are a known entity to your seller should they choose to terminate early. Hopefully they won't terminate early. Or if the seller does want to terminate the listing agreement, then another form I suggest you guys take a look at is the GAR F-152, the mutual termination of the brokerage agreement, where you do agree on any fees to be paid. All right, we are now up to the buyer brokerage engagement. We've got an hour to go to knock out the rest. So let's do this. It's a lot, isn't it? I talk a lot. Let's take a 15-minute break. It is 11:27. Let's come back at 11:45 a.m. We will knock out the rest. And again, I'm spending the majority of time on that because that's where the majority of the changes are. We will be able to cover everything. And when you get back in the chat section, I will put a link where you can get access to handouts. So let's take a break. It's 11:30. Let's come back at 11:45 a.m. When you do come back, once again, please type in your name, email address, and license number into the chat section. I am going to go grab something to drink and I will be back. See you guys back in 15 minutes. All right, everybody, welcome back from break. I hope you guys are learning a lot. It is a lot. This is the first time I'm teaching it, so there is a lot to cover. Again, I did spend the majority on the new seller, it's hard for me to say, brokerage agreement. The majority of the changes are in the brokerage engagements. We have another hour and 15 minutes, no, 45 minutes to knock out the rest of the class. Please, again, type in your name, email address, license number. I am also putting in there a website where you can get a video recording just for your reference, as well as I will, after class, immediately post a PDF of the slides so you can see them all. As far as actual handouts, the actual training versions of the 2021 GAR forms with all of my underlines and notes, we will email those to you separately. Before we continue, I am going to launch a poll. This serves as the course evaluation. You will see on your screen, there is a series of 4 questions. Once you answer all 4 questions, there is a button at the bottom. Right now it says submit in gray. Once you answer all 4 questions, it will turn blue. You hit submit and that submits the poll. If you have technical difficulties with it, don't worry about it. There is a little box at the top where you can X out and make the poll go away or minimize it. Please do your best to answer the CE poll. We're going to continue. All right, how we doing? So far, so good. Just a lot. It is a lot. I agree. Okay, everybody, I'm going back to sharing my screen and we are going to knock out the rest. So we are moving along with, okay. We are going to move along, moving into the buyer brokerage agreement. This is going to go quickly because as GAR does, a lot of the changes that GAR makes when that's something in a contract that's referred to in another contract, it is changed universally throughout all the forms. So very similar changes in the exclusive buyer brokerage agreement that were made into the seller. See, I even need to change my slide. Instead of listing brokerage engagement agreement, seller brokerage engagement agreement. Again, with the dual agency, it has it expanded in order to demonstrate that the buyer is giving their informed consent rather than just their implied consent. In the commission section, again, the language has changed for clarity. Instead of saying at the closing of the contract, it says contract to purchase rather than referring to the buyer brokerage contract or a lease or something else like that. It has the same section about the separate commission being paid on a lease. We've discussed all that. Under the extension, the same terms of the extension of the buyer brokerage agreement, but any extension must be, you must notify the buyer of the broker's decision to exercise that extension. You can either use that GAR form we've talked about, 158 notice to extend brokerage engagement agreement, or you can use just a general good old-fashioned blank notice, F816. Again, a further clarification of dual agency. You guys, I'm going very quickly through these because we've had a really good thorough discussion of all of these same topics under the listing, the seller's brokerage engagement. All right, under the commission section, it has been reworded and the sections all moved around a little bit. So it used to say, hang on one second. It used to say, this is the 2020 version, where that's what that looked like, who was entitled to commission on a for sale by owner, buyer default, so forth and so It has been switched around a little bit, and the default section, just like in the listing agreement, has been moved to paragraph C8. It does say, it used to say up here under commission, it used to say, well, not required. The custom in Georgia is for the seller to pay commission, blah, blah, blah. They've titled that paragraph and labeled it to make it a little more understandable, where it says seller normally pays commission. Under the protection period. Okay, you guys are going to like this one. You didn't like the listing protection period, but you're going to like the buyer protection period. The buyer protection period is different than the protection in the seller brokerage agreement. Again, this whole thing has been reworded. Basically, the protection period begins upon the expiration of this agreement. If the buyer, quote unquote, fires you, meaning they unilaterally terminate this agreement, that means they're defaulting on this list, on this buyer brokerage agreement, the additional protection time, the additional time frame that was left on the buyer brokerage from the time they unilaterally terminated gets added to the end of the protection period. There is no protection for your broker commission for a buyer if you mutually terminate the contract. And one change is that this defines, in 2021, they go on to define what is called a protected property. So basically what it says, in the event the buyer, again, this is under the protection. It says if the buyer basically goes under contract to purchase, lease, option, real property, and that property during the term that the buyer brokerage was intact, or would have been the term if the person didn't unilaterally terminate, that the agent or broker showed the property to the buyer, either virtually or in person, or which the buyer otherwise visited, those are protected properties. So, and your commission is due upon that. It used to be way more vague. It used to say something like property that was introduced to the buyer during the time frame. But this is much more specific regarding what properties are protected, and they are now labeled protected properties. But the difference is, even if the buyer, the difference from the seller brokerage agreement is, even if a buyer signs another buyer brokerage agreement with another broker, if they go back and buy one of those protected properties, you still have rights to that commission. Now, you're not going to have rights to that commission from the listing broker, but you will have rights to that commission by pursuing the buyer on the default of this buyer brokerage agreement. So under the seller protection, all bets were off once they listed with another broker. Under the buyer brokerage protection, your commission is still protected on properties that are protected properties, even if they go sign with a buyer brokerage with another broker. So, yep, I know you guys like that one, different from the listing. All right, same thing about the flood property being having a propensity to flood or being in a flood zone. Again, you guys, your buyers have got to check this out during due diligence. Yes, your lenders should absolutely check this out. For whatever reason, some of these lenders are not finding that. Some of these insurance companies aren't finding that, which blows my mind. So definitely you'll want to check with the closing attorney with the title and ask your lender, get your buyer to ask the lender to specifically check for that. All right, this same miscellaneous paragraph, very similar to the changes in the seller brokerage agreement. They've all been advertised. That same new paragraph about the attorney's fees, definition of broker, third-party vendors. There is a new section here under C7B, assignability, right here. This is not talking about a buyer or a seller assigning a purchase and sale contract. It means if a brokerage, if you're an agent with a brokerage and you sign a buyer brokerage agreement, the brokerage agreement belongs to that broker. If that broker goes out of business or gets taken over or sells to another firm, all the assets of that brokerage, including the buyer brokerage agreements, the listing agreements, the purchase and sale agreements, those would be considered assets of the firm. They get assigned to the new brokerage. In other words, this just because a brokerage, a public person is under contract with a brokerage and the brokerage gets sold to another brokerage, that doesn't give them the right to bail on the contract and go with another agent. Then again, it talks about buyer default and commission due if that broker would have been paid a commission and it is the buyer's default on that contract. Again, it is just this, no new information from 2020, just changed around in different paragraphs regarding what constitutes buyer default. Some of it was under commission and so forth and so on. And I think you guys will like this. They have added a special stipulation section in the buyer brokerage agreement. I don't have a picture of it here, but there is now a section that says buyer special stips. Okay, whoo. The protected properties, Monifa, I am going to let you look back at this. We've got a lot to cover, but it is clearly defined under the protection section under the buyer brokerage agreement. Okay, purchase and sale, y'all ready? Not many changes at all. This is going to blow your mind. This is the fewest number of changes to a purchase and sale agreement that I have seen by GAR in many, many, many years. So they really focused on the brokerage agreements this year. So first change under paragraph A7, where it talks about earnest money, they have added a checkbox for ACH. And anywhere in the purchase and sale agreement where they reference earnest money, they also reference that the form may be in ACH. Again, with the new terminology under the brokerage relationships, again, we're on the purchase and sale agreement, GAR F201. Let me just show you guys again what you guys will be getting by email. You will be getting copies of these actual training versions of the forms. I am also sending you guys a whole document that I have done on EPA and lead-based paint disclosures. You're going to get copies of these with all of my notes and underlines and handouts. So including the purchase and sale. So just something to look forward to. But for the purpose of the PowerPoint, I just sort of cut and pasted. Okay. Again, for simplicity of terms, under the brokerage relationships, now it says buyer's broker and seller's broker, rather than it used to say selling broker and listing broker. And again, I have caught myself numerous times, even in this class, changing that terminology. But this should be more clear to not only the public, but to other agents as well. Under the closing costs section, under the prorations, it has always talked about ad valorem property taxes, community association fees, so forth and so on, that the buyer and the seller agree to prorate after closing if necessary. They have added language at the bottom of that paragraph. Automatic ACH is the direct bank transfer from, sorry, I should have defined that. Directly comes out of basically a checking account and goes into another account. Under the closing cost section, they have added a section, verbiage that says the liability to the county in which the property is located for ad valorem real property taxes for the year in which the property is sold shall be assumed by the buyer upon closing of the property. The buyer agrees to indemnify the seller against any and all claims of the county for unpaid property taxes in the year in which the buyer is sold. That is brand new verbiage. Make sure your buyers understand what that means and get with your closing attorneys to check on the tax bill. All right. Under the paragraph B8, inspection and due diligence, this has been more clearly defined where it talks about the buyer and the buyer's representatives have the right to enter the property at reasonable times, including immediately prior to closing. Basically, it goes on to say that the right to enter the property shall include the time period after the end of due diligence to, among other things, and without limitation, meet contractors, measure for renovations, confirm that repairs have been done, so forth and so on. So apparently there was some misunderstanding and sellers were refusing to let buyers in after due diligence. So they've always been allowed in, but this just clarifies that the buyer has the right from the time they go binding through closing to enter that property with reasonable notice. Under the brokerage section, they have added a section that says the broker is a third-party beneficiary to the contract. In other words, receives something valuable such as money with respect to this purchase and sale agreement. Here we go again about the flooding and flood zone certification. There must have been a lot of issues. I know we had at least 2 issues that I'm aware of with that, but it must have been a predominant issue throughout Metro Atlanta, at least, or all of Georgia, for this to have been changed in the contracts. Under risk of damage to property, this paragraph C3, they've done 2 things. First, they've added the reference to this new form that the property shall remain in the condition, including any conditions disclosed in the regular good old property disclosure form or the seller's disclosure of latent defects and fixtures checklist. That's that new form they've added. And they changed the verbiage. It basically says if the property is destroyed or substantially destroyed prior to closing, and then it tells what happens between the buyer and the seller. Last year, it said if the property is destroyed or substantially damaged. So they changed that word to substantially destroyed. And again, we've already seen this verbiage in the brokerage agreements. This is GAR's protection section that basically says GAR, these are forms. However, courts have full jurisdiction. If this does go to a court, a judge may strike down or not enforce provisions in our GAR forms as written, regardless of what one or the other party may have intended. No representation is made by that the GAR forms will protect the interests of any particular party or will be fit for any specific purpose. That is, there's another term, but I'm not going to use that term. I'm going to use this as GAR's protection term. Now, the survival paragraph, this is paragraph C4L. So in GAR, there are 6 things that survive the closing of the GAR contract. Paragraph 3, it used to say all representations of the seller regarding the property. They have changed it in 2021 to say all written representations of the seller in this agreement regarding the property or neighborhood. So they've added written and they've added neighborhood. They've also added this section about property taxes. The obligations of the parties regarding ad valorem real property taxes survive the closing. And then this has always been in here, but I just want to bring to your attention, it says any obligations which the parties herein agree survive closing or may be fulfilled after the closing. But you'll want to remember this magic phrase, this provision shall survive closing. For example, if the buyer and the seller negotiate for repairs, but you do a walkthrough and the seller has not completed all the repairs, well, number 1, that doesn't necessarily give the buyer the right to terminate. But number 2, if you didn't write that in there and you close, the seller is not contractually obligated to complete the repairs unless you put in that magic phrase, this provision shall survive closing. So you absolutely want to use that magic phrase when you're addressing repairs, when you're addressing, for example, a seller to purchase a home, to pay for a home warranty for a buyer, things like that. You'll absolutely want to use this provision shall survive closing. That legally puts the obligation on the seller to still fulfill that after closing. If you do not write that magic phrase in, it does not automatically survive the closing. And this new language has been added above all the signature lines in all of the forms. It says, by signing this agreement, buyer and seller acknowledge that they have read the agreement, they understand the agreement, and they agree to the agreement. So again, I believe this is going to the point of actual informed consent to everything rather than implied consent. And this verbiage is again above every signature line in all of the contracts universally. That's it. That's it for purchase and sale. All right, if you have a property listed, buyer gets hurt, how are you protected from being sued? You're not. So anybody can sue for anything, whether you successfully defend yourself in a lawsuit and what's in the contract or not. That's why GAR put in that verbiage that a judge can change anything that's in the contract. But yes, E&O insurance, you would get with your broker, get with your E&O insurance, see if it's an E&O claim, and proceed that way. Okay, counter offer form. Ooh, you guys, I love this. I love this. So in 2020, in the counter offer, it basically said the party, any and all previous counters made by either party are hereby rejected and not part of the agreement. In 2021, I love the new language they added. They added the party making this counter offer acknowledges that in doing so, number one, it constitutes a rejection of the original offer as presented and a rejection of all previous counter offers. Number two, just in case you didn't understand what I said in number one, the original offer and all previous counter offers are no longer available for acceptance. Number three, no previous counter offers shall be considered or part of this agreement, and number four, nothing requires the other party to continue. So you guys, this is great. What was happening without this verbiage is you would have a buyer write an offer to a seller. A seller, let's say, wrote a counter offer to a buyer. A buyer wrote a counter offer to a seller, going back and forth, back and forth. Well, the last counter offer, there was never a counter offer that was agreed to. But if any of the other offers still had open time frames, the party was going back and signing the counter offer from 2 counters ago and going binding with the contract. And the seller was saying, well, no, that was off the table. I didn't mean that once I made another counter offer. Well, contractually speaking, if the time frame was still open and that offer or counter offer was not withdrawn, it was still open and available for acceptance, even though further counters had been tendered. So this is great. This says once a party initiates a counter offer, there is no going back. Everything else is off the table. So I think this is great verbiage to avoid confusion. And again, just for clarity, it says when the counteroffer is signed by buyer and seller and copy of the same is delivered to both parties, the original offer as modified by this counteroffer is what actually constitutes the legally binding agreement. And then this has always been in there since the original offer, including exhibits, is incorporated by reference. It does not, only the counteroffer needs to be signed to create the legally binding contract. And again, that same verbiage above the signature lines that they read, understood, and agreed to everything in the counteroffer. Okay, new form. Let's see what you guys think of this one. It is the request for confirmation of presentation of offer or counteroffer. It references license law and it references the Realtor Code of Ethics. And I can't make this Let me see if I can zoom in. This is license law. So this applies to all licensees in the state of Georgia, whether you belong to a board of realtors or not. Additionally, per the Realtors Code of Ethics, Article 1, this applies if you are a realtor and belong to a board of realtors and thereby NAR. So this is for all licensees, whether you belong to a board or not. This is an additional reminder that per the Realtor Code of Ethics, you need to present all offers, period, end of story. The issue is, there was a lot of question, is whether offers were actually being presented to sellers. This form has a place of the signature of the requesting broker and the signature of the responding broker. And it says the responding broker affirms that the above referenced offer or counteroffer was presented to their client on or customer on whatever date. What don't you see in here? What do you think of this? Yep, there's a lot of times that a lot of agents feel like their offers or counter offers were never presented. Yeah. Who's signing this form? Type in the chat. Let me rephrase that. Whose signatures don't you see in this form? Yep. Yep. You guys, this form is only signed by agents. This is not signed by the seller or the buyer. What do you think? No client signatures. What do you think? What do you think? BS, not much good, useless. So y'all don't think much of your colleagues. Again, that's why they give this reference to license law and the Realtor Code of Ethics, that your colleagues should all be honest and forthright and upfront, that if they say they presented the offer, this should suffice that they are presenting the offer. But we do not have any certification on this form that the public buyer or the public seller actually did see the offer. So there is another form that the public actually signs, and that is the GAR Form F288, Notice to Reject the Offer or the Counteroffer. Point of practice for you guys as agents: protect your license. You guys should sign this new form if you are presented with it, but you should always get your public to acknowledge that they actually did see an offer and it is their decision to reject an offer or a counteroffer, especially in a multiple offer situation. So just so you know, there is GAR F288 that has been in existence called Notice to Reject Offer. This is the form that is signed by the buyer and the seller. The problem is you can't require a buyer and a seller to sign a form. This new form, F289, is only signed by the two brokers / agents involved in the contract. And you hope they are being professional and honest. And that is why they have this reminder of license law and the code of ethics. So, yep, interesting. Interesting comments. Okay, another new form. Let's see what you guys think of this one. GAR F290, Agreement to Reinstate the Contract. Brand new form, brand new form. It is an agreement. It is not an amendment. Once a contract has been terminated, it is dead. You cannot amend a dead contract. Now, if the contract expires, if all the time frames merely run out, you can amend by agreement of the parties' written acknowledgement of their desire to move forward. But you really can't amend a terminated contract because it's terminated by a party's signature. A party chose to terminate. The problem that we have been having is that many buyers specifically were choosing to terminate a contract prior to the expiration of a contingency timeframe to protect their earnest money, but they still wanted the property. They were just waiting on somebody else. For example, let's say buyer and seller under contract, property gets appraised. The appraisal comes in low. Well, the parties have petitioned the appraiser to do an appraisal review, but that takes time. In the meantime, we're coming to the end of the appraisal contingency, and the buyer wants to protect their earnest money. They still want to they still want to buy the property, but just in case the appraisal review doesn't raise the price, they don't want to lose their earnest money. So what was happening is these buyers, for example, were terminating the contract to protect their earnest money. Then let's say the appraisal come back fine. Well, the lenders were saying, well, just write an amendment to the contract, bringing it back. You cannot amend a dead contract. So the lenders are saying, well, once it's terminated, I can't reinstitute this loan. Buyer has to wait, in some cases, up to 30 days. But we have a buyer and a seller that want to proceed. You guys, you cannot amend a terminated contract. And earnest money has to be dispersed on a terminated contract. So this form was created this form was created to do that. It alleviates your brokers from the unauthorized practice of law. It alleviates your brokers from having to interpret contracts in favor of one client or another, even though a terminated contract is a dead contract. It does bring the contract back to life with no changes other than whatever had already been into effect prior to the termination. Now, there is a section for fill in the blanks for changes, but those fill in the blanks are not designed to actually amend the contract. But you might need to change a contingency timeframe. Let's say the parties terminated a contract and it's a week later and you get the appraisal that comes in at sale price. So you want to use this form F-290 agreement to reinstate the contract. But 5 days have passed. So we could be out of the appraisal contingency timeframe, or we could be past the closing date. So there is a place in this new form where you would change. Really, it's really designed for to address a contingency time frame or something that hasn't passed, or regarding earnest money if it had been dispersed. If the status of a contract doesn't close on the specified and no amendments are in place, then it just expires and you can amend an expired contract. This is just if a party sends over a notice to terminate. Now, there are a couple of things to keep in mind. There are no time frames on this form. So if a contract is terminated, when can this be used? How much later in time can you reinstate the contract? A day, a week, 2 weeks, 3 weeks? Not addressed. I asked the GAR Forms Committee. I asked the attorney of the GAR Forms Committee. There was no answer. So not sure, that might end up getting decided by a judge this year, not sure. And also be aware, if the contract was terminated with a TNR, if earnest money was dispersed, and then you use this new form F-290 agreement to reinstate a contract, you might need to address earnest money in the revival of this contract if it had already been dispersed. All right. Moving along, the Community Association Disclosure Exhibit. There were a lot of changes this year, but you guys, there were not a lot of changes to the content. Just the organization and the rearranging of the paragraphs and the use of bold font to help clarify which party owes what money. So they changed a couple of things. Let's see. Where it talks about an annual total cost for any membership. It has a new section where they separated out utility expenses that are part of the fees. They have separated out under the assessments for services and amenities. They have separated that out. So it has services and amenities for the actual property versus services and amenities for the common elements of the property. They have renamed this section fees paid at or prior to closing. They've bolded seller shall pay, buyer shall pay, seller shall pay, buyer shall pay. Again, this is nothing new with respect to the actual content of who pays what. It's just been reworked and reorganized to help make sure that the parties understand who is paying what. Sale or lease a buyer's property contingency exhibit. This one has been changed pretty much. I can't make it bigger right now because I want to get through everything. Okay. Sale or lease a buyer's property contingency. Again, you guys will get copies of these forms after class, and I will post a copy of these slides. So they changed a lot of stuff. I'm going to go over this a little bit more in depth. When it says under here where it says at the time, okay, let's see if I can zoom. Where it says at the time of the offer, the buyer warrants that the property is, they've clarified that. So basically it says currently listed with whatever broker, currently under contract with the buyer being represented by another broker, and a pending date of or closing date pen that's just for use with an existing pending contract or other. So you further clarify what is the status of the buyer's current property. You guys, this is great for listing for sellers. Then it goes on to say that this agreement is contingent upon, that's always been in there. You have to fill in the date of the contingency period. Now they've added a lot of specific requirements that a buyer must do to show that they are in fact really trying to sell or lease the property. It says buyer at closing of the sale of property. If it is contingent upon the buyer's selling the property, it says unless the other property is already under a binding purchase and sale contract at the time of making the offer on the new property, the buyer shall keep the other property listing for sale with the real estate broker at a sales price of, not more than. So the seller gets to tell the buyer, I'll go under contract with you and I'll make it contingent upon you selling your property, but you can't list it for higher than X amount of dollars until it's either sold or closed. Same thing with specifics for leasing their property. Then again, there's no changes to this paragraph 4. I just want to remind you guys that if the buyer does not sell or lease their property before this time frame, the contract for the new house automatically terminates. And this is a brand new paragraph 5, talking about the buyer's obligations to keep the seller informed. It says, in the event that the existing pending contract, so this is of a buyer writing a house for a new property, but I've got to sell my current home, but I'm under contract. If my contract on my current home is terminated for whatever reason, the buyer must immediately notify the seller. The buyer shall have the right, but not the obligation, to terminate this agreement for the new house, and they'll get their earnest money back. If my pending deal on my current home terminates, but I don't terminate the contract for my new house with this new seller, the seller has the right, but not the obligation, to remove all contingencies, including due diligence period. The seller only has 3 days to exercise that right. If the buyer doesn't deliver the amendment within 3 days of the seller's request, the seller, so I live in a house now, I'm under contract, I'm going to buy my new home. The contract on my current home falls out. As the buyer, I can either terminate the contract on the new home and wait and go find another home. Or, first of all, I have to send notice that the seller can say, great, I'll stay under contract with you, but you're removing all contingencies. And the buyer can say, nope, I can't do that. I'm going to terminate and I'll get my earnest money back. If I don't do that, then I'm like, okay, I agree. And I remove all contingencies. So this is brand new paragraph 5. Then this section, paragraph 6, the kickout clause is explained. And again, that was actually a change they made mid-year 2020. The kickout clause explained is separated from the actual terms of the kickout in this transaction, which is now in paragraph 7, where it talks about if the contract is subject to a kickout, then if it gets kicked out, are all contingencies removed or only certain contingencies removed, or not subject to a kickout. So again, that was changed mid-year 2020. And love this too. They have added a section for special stipulations on this sale or lease of buyer's property contingency exhibit, because there's a lot of things that come. Yeah, these are good changes on this. Whew, we're getting there, you guys. We're almost done. All right. Consumer brochures. Under the protect yourself when selling a home, they have added a whole section about property marketing and coming soon status. They have also added a section on capturing and sharing media that basically says, hey, we have no control over it, but sometimes a buyer is going to take pictures of your home as they are seeing your home. Under the CB13, it used to say protect yourself when buying a home. It now says, so the first one was selling, this is buying. Now it says when buying real property. They've added language about consulting with a termite company, not only for existing termite issues, but about preventative treatment measures. And under the section where it talks about, I don't have it here. There is a section about thoroughly investigating the property. Again, we're talking about the consumer brochure, protect yourself when buying real property. They've moved this to the beginning of the brochure. They've updated the information about the lead-based paint. They've added language about termite prevention. Excuse me. They've added language about latent material defects. Basically, it is more admonition to keep in line with Georgia being a caveat emptor state. Buyer, the burden is on you to check out the property. You agents, you guys, you've got to use these consumer brochures. When working with a buyer, get them this brochure. When working with a seller, get them the CB10. Get them all consumer brochures available to you regarding their particular situation. It will absolutely, and ask them to read them. It will absolutely help you throughout the process. All right, you guys, those are the main changes. There are changes to the lease. This is a list of the changes to the lease for residential. There are changes to the new construction purchase and sale and new construction exhibit. These are a list of changes here. Again, I'm sending this to you guys. I just wanted you to be aware of some of these changes. There are changes to the commercial purchase and sale. You can see pretty minor, nothing major. There is a brand new form for you commercial agents. It is an exclusive commercial lease listing agreement. This is a brand new form. And there are some other, all the changes that we've talked about regarding the brokerage agreement, so forth and so on, are consistent. What do you think? We made it. We made it. Again, in general, please confirm all contract questions with your broker. We have additional courses available for you. We just got confirmation that GREC is allowing virtual classes throughout all of 2021. So you do have the calendar. Okay. The calendar is available for courses offered through the Georgia Real Estate Academy. If you go to register for reclasses.com, if you select Marietta, that is the default calendar for all of the virtual classes that are offered through the Georgia Real Estate Academy. Again, handouts will be available at eagentweb.com. Select training videos and scroll through the page for this class. This class has been hosted by Maximum One Realtors Companies. Credits will be recorded within 3 to 5 business days. I have a YouTube channel. It is called Real Estate Made Crystal Clear. I have over 5 years of real estate contract tips and license law tips. Please feel free to check out that channel. I have started a series on the 2021 GAR contract changes where I go into a little bit of these changes really in depth. So please check out that channel. It is designed for all Georgia real estate agents. And in general, everybody, please, this is going to be the most celebrated New Year's Eve of all times, I think. Have a joyous and prosperous 2021, helping others with their real estate needs. And I am going to stop my share right now. Again, once more, before you leave, please type in your name, license number, so forth and so on. But I will stay on to answer any questions. I'd love to hear your general comments, what you think. And I'll be here to answer any specific questions that you guys have. Thank you guys so much. I appreciate your time. And it was a lot of information. Yeah, the YouTube channel, just go to YouTube. It is just Real Estate Made Crystal Clear. Whew, a lot of information. My pleasure. All right, any questions, you can either type them in the chat or you can unmute yourself. If you're not asking a question, please keep yourself muted so we can hear.
Dana, this is Peggy Devoni. I have a couple of questions.
Hey, Peggy.
How you doing?
Good, how are you?
The new latent defects form for the seller's disclosure, are both of those required, or the latent defects only is attached after you had an inspection and something is shown?
No, it would be, if it's after an inspection, this is designed for, it's designed for a seller who does not want to fill out the property disclosure form because of the survival clause. There are a lot of sellers, specifically an estate. Look, I just inherited the property. I've never lived there. A foreclosure or a company that has purchased it, an investor. I've never lived there. I have an issue with investors not wanting to fill them out because there are a lot of investors that know a lot more about their investment properties than I even know about my home. But nevertheless, the issue is a lot of sellers are not willing to put anything in writing about the property because the survival clause in GAR says any warranties of the seller about the property survive closing, and they don't want to be sued on something. And so that's number one. Number two, if it is someone that owns the property, for example, an estate where I've never lived there, I really don't know. But if a seller does have specific knowledge of a late material defect, asbestos, a leak that, my mom always talked about the leak in the basement. I don't know about it. I know she mentioned the leak. I know it's hard to find. There is still the Georgia law under the tort section of deceit and fraud where a seller is required to disclose that. Well, there's nothing that says the seller has to disclose it in any form, but you as the agent also have to disclose it. So this is GAR's attempt to create a short and sweet form that a seller could fill out to stay in compliance with Georgia state law, but not necessarily put additional information about the house that they might be held to legally as a survival issue. So the question then is, well, what if I am an owner occupant? Can I use this form rather than the full-blown seller's property disclosure form? And yes, the answer is yes. Again, the other question is, if a seller has knowledge of a latent material defect, they don't even have to use either of these two forms, but they do have a legal duty to disclose. They could disclose it on a notice form, they could disclose it on a piece of paper, but there is that legal obligation. So this is GAR's attempt not only to help them just disclose a latent material defect without having to answer all those other questions. The age of the HVAC, the age of the roof, when was this replaced, what was done here, blah, blah, blah. Especially a lot of investors who have done some renovations to the property. Well, there were some things they could fill out. They just didn't want to put any of that in writing. And additionally, they've added that fixtures checklist to that because it's like, yeah, I'm leaving the curtains, I'm leaving the fixtures, I'm leaving this fridge, blah, blah, blah. Did that answer your question?
Yes, I have two more questions real quick.
Okay.
I know we have the lead-based form. Are they doing anything or considering a meth form for some of these meth houses?
No, they're not doing that for the same reason. And I believe it falls under that section of the law. And I don't remember at this point which code section of the law it is, where the non-disclosure, where we have what a seller must disclose, but then there's also a section of what the seller is not required to close. For example, the sex offenders. The same is true of a meth house because number one, the seller might not have knowledge. Number two, if the seller was participating in the meth production, they might not want to disclose that for a variety of other legal reasons. But the burden is on the buyer, which is why in the purchase and sale contract, and I think it's in the buyer brokerage too, it does have a link. The sex offenders registry link has been on the GAR contracts for years. I believe it was either last year or 2 years ago where they added the website where you can check to see if it is a known meth house. There is that link to the website as a courtesy for a buyer to check it out on their own.
Okay, and my last question is the new form where the broker has to acknowledge that the offer or counter offer was shown to the corresponding party.
Correct.
Oh boy, your job's going to be really busy there. So, I feel in some of the transactions that I've tried to do, I don't feel my offer was presented. So
You are not alone in that sentiment, Peggy.
I know. And so now with the with this form, you're in a multiple offer situation. The listing agent stonewalls me as a buyer's agent and no response at all. And then all of a sudden it shows up as under contract, someone on their team. And you get the feeling that something was just not kosher. So I send the form over to that agent at that time, or to the broker at that time. How is this? I'm stumbling with what I'm saying. How is this all going to, so it's after the fact that, they're already under contract and I send this over. Is there any use in doing that, I guess?
Well, let me ask you, what recourse does any agent / broker have against another agent / broker for perceived lack of performance?
You'd file an ethics complaint?
Well, if it's a realtor, you would file an ethics complaint. If it's not a realtor, or in addition, you could also file a request with GREC for a license law violation. That's why that form has the reference to the license law as well as to the Realtor Code of Ethics. Is that going to help your buyer get that property? No.
No.
Is that potentially going to sanction that agent / broker? Yes, because proof. What proof do you have? Well, nothing at this point. Again, the public buyer or seller doesn't sign that form. That is just for agents / brokers to sign. And you hope that your colleagues are professional and adhering to license law and adhering to the code of ethics. If you could get the public to sign that rejection notice, that actually helps. Again, after the fact, nothing you can do, but there's nothing also, well, let me finish this thought. So in a hearing, or even if you go to litigation or arbitration, if it got that far, but really this, you could call the seller or the buyer, if it's a counteroffer, as a witness. And they would be under oath in the hearing to say, yeah, I saw that, or, oh my gosh, I never saw that, I wish I had. So this is, and then if you had presented this form, the other agent signed it, and then it still, the recourse would still be through GREC, license law violation, request for investigation, or an ethics hearing. there would be further sanctions if they further lied on this form against that thing. Again, it doesn't help your buyer get that property.
Is
But
there,
the other thing is, guess what? You guys, the seller, just because the seller gets multiple offers, the agent does have the duty to present offers. Even if you're under contract, you have to present offers. But there's nothing that requires a seller to call back for highest and best or do multiple counters. A seller can accept any offer they want. But exactly, in terms of you representing a buyer, you want proof that at least, because then you're hard pressed to explain to your buyer, your buyer's like, you told me to go in at this price, blah, blah, blah. I did, and I still didn't get it. And especially right now in our fast market where there are fewer listings than there are buyers, it's very precarious right now.
is there any chance or thoughts of amending that form where the client, the buyer or the seller have to sign it?
Well, there's no need to. It would be the other form, the rejection of offer form.
Okay, but that's not, none of these forms are mandatory. So I can send it over to you and you can ignore it like you ignored the offer that I sent it.
Yeah, of course. Of course.
Okay.
There's no, and the thing is, for those of you guys that have taken the Realtor Code of Ethics course, that whole section on pathways to professionalism, there's a whole lot of things on that under professionalism and courtesy that isn't even addressed as an actual article or I can't think of what the supporting stuff is under the Code of Ethics. And it's not necessarily, being unprofessional is not necessarily a license law violation. Not presenting an offer is a license law violation, but not commuting back with your colleague or co-op, it's unprofessional and it's difficult, but it's not necessarily a violation. And that's where the brokers end up. One broker, the first thing you would do is try and work it out professionally between the agents, and then above and beyond that, you would contact your broker and try and get your broker to contact the other broker, which hopefully gets resolved that way. Unless the I'm not going to go there, but those are the first attempts you would try.
Thanks so much. I appreciate it.
Yes, my pleasure. Yes, Brent, I am going to post a PDF of the changes in that website. The PDF of my actual slides. I'm going to put it again. It's going to be eagentweb.com under training videos, and then you'll scroll through. Any other questions, anybody?
Yes, I have a question.
Hey,
This is Jackie.
Hey, Jackie.
Hi. Earlier you said that there was a misunderstanding with the title of the classes that were posted, and one of them did say contract dissection, which is December 22nd. I signed up for it. However, I'm trying to figure if that was one of the wrong one, and maybe I need to cancel myself out of that class if it's going to be the same changes that we just did today.
On the 22nd?
Yeah, it does say concept dissection for that day.
No, that is this class. That is the wrong name, because the course number, what you guys really need to look at is the course number. It is the same course number. It is the same class. It is just the changes. So you don't need to attend that one. You could attend it, but you are not going to get credit for it.
Okay, no, I was just checking it in my thing, and it says dissection. Yep. So let me just double check that with you.
I appreciate that, and I'm going to change that right now, actually.
Hi, Dana. This is Vanessa. How you doing?
Hey, Vanessa. Good. How are you?
I'm doing okay, honey. I have a couple of questions. Well, number one, that question about the variable rate, the commission on the sellers, in other words, the listing agreement. Tell me some more about that. We can change the percentage.
Okay, so let's talk about that. First of all, number one, all you listing agents, you should always mark yes to variable rate commission in your MLS services, period, end of story. The reason, what that means is in your MLS listing, you advertise a co-op commission that an agent / broker working with the buyer can expect as a commission should they be the procuring cause of sale and their buyer go under contract with your seller. I can reasonably expect whatever co-op commission is advertised in the MLS. Now, this is going to be further clarified with the commission instructions in writing, but going into that, because we cooperate through the MLS services, I can reasonably expect that. So basically the commission, if any of the commission structure changes, you need to mark variable rate commission. Because number one, you need to dictate that my commission can change. Number two, you need to dictate that your commission can change. Let's say you're the listing agent, and let's say you make a deal with your seller, all written out on your listing agreement that says, if no other agent is involved, in other words, if I get a sign call, I'm already representing you as a client. If I get a sign call and work with that buyer as a customer, number one, it's not dual agency. Number two, my broker, if my broker allows it, I may make a deal with you that I am not going to charge the full commission that you're not obligated to pay the full commission that you would pay if another agent or another broker is involved. I'm going to give you a break because I've got both sides of it.
Mhm.
You have to communicate that you have a competitive advantage. It's a better deal for a seller for you to get both sides of a deal because they're going to pay less commission. You have a competitive advantage. So number one, that would be the effective use of marking yes to a variable rate commission. Number two, there's a lot of listing agents that say, look, if I show your buyer might have a buyer brokerage agreement with you, but the buyer was driving by, was putting the sign in the yard. They wanted to see it. I showed it to them. They can still work with you. You'll still get commission, but instead of getting this amount of commission, I advertised as a co-op fee in MLS, I'm only going to pay you a lower percent. That's a variable rate commission. You have to communicate that in the MLS service because we're not under contract yet, but it's what reasonably can expected. So you should always mark variable rate commission, yes.
In the MLS.
In the MLS and in the private. And in the private remarks, you have to put, if I show your buyer, the commission will be, but it's not just your decision. You have to have consent of the seller. And when these cases went to court or arbitration, the bottom line was what the seller had agreed to in the listing agreement. So a lot of savvy listing agents were adding that as a special stipulation because that was the end, that was the definitive answer of whether a listing broker could change the co-op commission or not. If it wasn't necessarily in the listing agreement, it wasn't necessarily an authorized change of a co-op agent's commission, which is another license law issue. So GAR has put that whole section in there in the new seller's brokerage agreement to spell it out. The seller gets to dictate what you do with my money. A lot of sellers won't necessarily agree to a listing broker offering a buyer's broker a lower commission. I'm hiring you to sell my house. You need to offer the buyer's broker a higher commission. I want you to give them incentive. So a seller might not agree to that co-op split if you're changing it. That's why it needs to be in the listing agreement. Now, again, as was asked earlier in the class, if a buyer's broker says, hey, show me the listing agreement where the seller agreed to that, a listing broker can say, I'm not sharing anything with you. That is a confidential contract between me and the seller. Now, if I get subpoenaed by court, then that's a whole different issue, and it better be in there.
Okay.
The other reason where variable rate commission comes in is not necessarily anything like that, but you guys, throughout the course of events, both brokers, you guys are negotiating, everything's all groovy. Then there's repairs that get negotiated, and then the appraisal comes in low. Well, sometimes the brokers will change their commission. You guys will buy a home warranty for a buyer or for a buyer. You guys will kick in part of your commission as a rebate. You guys will kick in part of your commission to make the deal work for a low appraisal or for whatever reason. That is varying the commission rate. That is changing the commission. So that's why you should always also, in my broker opinion, check with your broker, in my broker opinion, you should always mark yes to variable rate commission, because throughout the course of negotiations to kind of get the deal to work, there's a lot of times that both brokers mutually agree to alter their commission for the good of getting it to close.
So, okay, but when we put it in that listing agreement, that's not so much as our broker agreeing to it.
Yeah, it is. Why do you say that?
I mean, if I lower my commission because I want to pay the home warranty, my broker may say, well, I'm still going to charge you the 3%.
You can't do that. You guys, you are all affiliated licensees. You are affiliated with whom?
The
Your broker.
broker,
All contracts belong to whom?
the broker,
Your broker. All commission money belongs to whom?
the broker.
Your broker. You cannot alter my commission without my permission. Now, how do you get paid? How do you know how much you're going to get paid on any one transaction? What's the document? What's the contract? What documentation is signed where you, as the affiliated licensee, the agent, where you know how much money you're going to get paid on any one transaction? What is the documentation where that is all spelled out and agreed to?
The attorneys?
No. The attorney,
No, I mean, the instructions to the
No.
attorneys. No?
Nope. That is how much the listing broker is going to pay the selling broker. That's still all broker commission. And I don't mean to be putting you on the spot, Vanessa, but through
No,
there's
the
a lot of
listing
people-
agreement, then that's the
No.
listing.
No, listing agreement is how much the public seller is paying the listing broker. Still my money.
Mhm.
Keep
So now-
thinking.
Tell me your question again.
What is the documentation that is signed where you as the agent know how much you are going to get paid on any one transaction?
Oh, okay, it's the agreement that you have with your broker.
Yes, ma'am. The
Mhm.
independent contractor agreement
Independent,
is the
yeah,
only thing that is signed, because you can only get paid commission from your broker. You get paid a commission based on what you and your broker agree to in the independent contractor agreement. That's one of
Right.
the many variables you guys look at when choosing a broker.
right.
All the money related to a real estate transaction is all my money. Thank you very much. It's all broker money. So any concessions to commission with an agent giving a rebate, buying a home warranty, so forth and so on, you absolutely need the permission of your broker. Now, you may not need that permission with every specific individual transaction because your broker may have already granted you that permission in the independent contractor agreement or policy manual of that firm. So there may be a blanket permission that you as the agent, as an affiliated licensee with me and my brokerage, I give you permission to alter my side of the commission in any way you deem that you want to do up to X amount of dollars that you owe me. But that permission,
Mhm.
like I said, there can be
Oh.
a blanket permission in the independent contractor agreement or in the policy procedures manual.
Mhm.
But if that is not granted, there are some companies where you absolutely may not alter commission. You may not buy a home warranty for somebody from your commission unless you get specific written permission. You may not give a rebate to a party without specific written permission per transaction. Other firms are set up where that blanket permission is you're an independent contractor. It's your business. You can do what you want. As long as you pay me X amount of dollars, I don't care
Okay.
what you do with your money. But
I
at
see
the
what you're saying.
time of the transaction, it is all broker money. It's not, and any commission issues of you as an agent getting paid, that would be a contract issue based on the independent contractor agreement. All those other documentations is public. The listing agreement is how much the seller agrees to pay the listing broker. The buyer brokerage agreement is how much the buyer agrees to pay the buyer's broker. The commission instructions is how much the listing broker and the buyer's broker agree to pay each other, or rebates given back. That help?
Mhm. But in other words, all of that is, you can only do that with your side of the money. Is that what you're saying?
Yes, yes.
Yeah.
And there is a license law that says you cannot alter a co-op broker's commission without their written consent. Now,
Well,
the
of course.
brokers, each broker / agent, you guys can negotiate for that, but you cannot say that. So the written consent, so now you're going back to the thing. Well, what about it says, if I show your property, if I show your buyer, I'm only going to pay you X%. Well, because you are a cooperating member of that MLS, you are agreeing to that when you go under contract. It's further signed in the commission instructions. But you know, now the problem is we've got buyers. And so basically, let's say you're a listing agent. You are putting a sign in the yard. Buyers drive by, they stop on the curb. They're like, oh my gosh, this is my dream house. They go up to the listing agent. The listing agent correctly says, hey, are you working with an agent? And they say, yep, we have a buyer's agent. We love our buyer's agent, but oh my gosh, this is it. We know it's it. Please, 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 can we see this house? Now, technically what should happen, the listing agent has asked. The listing agent either needs to say no, but the listing agent has also been hired to sell the house. You've got a buyer drooling to be in this house. But if you're like, well, I'm only going to pay the buyer's broker X% if I show them. Professionally, what should happen is that listing agent should say, sure, no problem. However, hang on, let me make a call to your agent and call the agent and say, hey, look, I've got your buyers here. They want to see my house. Do you mind if I show them? By the way, if I show them, I'm only going to pay you X amount %. And then the buyer's agent can say, no, I'll be right there in 15 minutes. But then that kind of puts the public in a bad situation. But technically, that's the communication that should happen. Should happen.
Yeah.
That help?
Yeah. And one more real quick question. I've been noticing a lot of buyers agents are offering like much higher than the list price. And then some of them say that if the next offer is higher, I'll pay $1,500 more. You know, is that's something that's been going on in this aggressive market here?
Yes, that's called an escalation clause. And actually, I have done a whole YouTube video about it with the proper verbiage of an escalation clause. But yes, that is a tactic that is very, very much widely used.
Yeah. So you have something on YouTube on that escalation clause?
Yep, I'm going to put in the chat section the name of my channel. It's called Real Estate. And again, per Greg advertising laws, I do have to advertise because I am the broker and affiliate with Maximum One Greater Atlanta Realtors. But please know that my channel is designed with my audience as 8 real estate agents in the entire state of Georgia. I'm putting it in the chat right now.
Is that the crystal clear?
Yes, ma'am.
Oh, I've got it.
Again, I really go over, it's not a lot of lead generation. It's not tips like that, but it is mostly contract tips on the GAR forms, on the RE forms. It is situational issues that happen with contracts that we have seen. I cover a lot of license law issues, just a lot of information, and they go back 5 years. Obviously, as the contracts get changed, I've got all the video recordings of CE classes and handouts linked there for informational purposes. So there is a ton of information there. And again, it is designed, I am such a firm believer in education and training that
Yeah, you are.
all real estate agents, the better informed and knowledgeable you are, the better it is for our industry, our profession, our clients. And then personally, I'd rather have an agent with another brokerage doing a deal with one of my agents when I know they took my class. So
are you going to be doing any classes on short sales? Because I think that's going to start next year.
We have a class approved, but I don't have it on the calendar anytime soon.
Okay. All right, I'm through. Thank you.
Thanks,
and happy
Vanessa.
happy holiday to you, Dana.
Thank you. Same to you.
I
Any
just have,
questions? Okay.
Oh. I just have a really quick question. So, on YouTube, you know how you see people who like record houses like they'll be like, oh, this house in Marietta or this house in Paulding. Do they always have written, and it's not their house, like, it's not their listing.
Right?
Do they always have written permission from the listing agent, or how does that work?
Well, they better if they want to be in compliance with license law. License law says that in order to market and YouTube, anything, Facebook, that is marketing a property, you must have written permission of the seller or the seller's authorized agent, which would be the listing broker / listing agent. But that is a great, so yes, it should not be on Facebook, YouTube, Instagram, Twitter without the written permission of, like I said, either the seller or the agent if the seller already has it listed. If it is a license law violation. But for agents, getting that permission and marketing it, that's a great way that a lot of agents will get buyer business from that, marketing a listing, even if it's not your listing.
Yeah.
That's what
And
the
then
reciprocity is all about too. All the brokers that have signed that agree that's why you can pull up ABC Company's website and you'll see all the MLS listings, because the brokers that are members, when we sign our membership agreements with FMLS and Georgia MLS, we give that written permission that all of our listings can be marketed by other brokers.
I have a question.
Okay.
You hear me? I'm sorry, but I little confused still about the commission. The listing agent can change the commission for buyer agent in the last minute?
No, absolutely not. You must have written permission to change a co-op's commission.
Okay, but you say that I understand, you say that if he had this one signed in his agreement with the seller, he can change that for me or for just for him?
For you too, but it has to be already marketed and advertised. For example, in the private remarks of MLS, it would have to say, for example, if I show your buyer, I am only going to pay a lower commission.
Yeah.
If they don't have that in there, technically they can't change it without your written agreement.
Okay. And now I am better. Thank you.
You're welcome. Good to see you, Marisol.
Thank you.
Hey, Dana.
Hey, Tanya.
I just have a question about a situation I haven't come into yet, and it kind of came up with the changes that you just presented in the new sale of contingency of sale form. But for this year, 2020 forms, how does it stand? Because I'm representing the buyer and they have a house that they're selling in Texas. But they ended up having a foundation issue that was discovered on the buyer's inspection on that end. And so now they're thinking about maybe not selling at all and just staying in Texas. So I guess my question is there any way if they want to, do we need to let their house sit on the market until that, expires, until that contingency of sale expires? Or because it might be in the best interest of the seller of the house here in Texas for us to terminate early so they can get their house back on the market as well. Is there a way for us to terminate early and my buyer still keep their earnest money, or do we have to wait for the time to run out?
So how much more time? Well, it hasn't happened. So yes, that is a point of negotiation. Right now, if the buyer terminates, and outside of all other contingencies, if a buyer terminates prior to whatever date you had put in there, the buyer will be in default. So for the buyer, what the buyer, just how it shows on paper, what the buyer should do is just do nothing, let that time frame expire, come and go, and then the next day the contract is terminated, it has expired because the buyer did not meet that contingency, then send a TNR and the buyer will get their earnest money back. However, the seller has incentive to go ahead and let the buyer terminate, because the seller is now staying on the market tied up, not selling it to someone else when the buyer knows they're not going to close. So buyer's agent should contact the seller's agent, say, look, here's the situation, blah, blah, blah. We want to protect our earnest money. So we have an option. Either we're not going to do anything and we're going to wait for another 20 days till this contingency time frame expires, and then we're going to get our earnest money back. Or we can agree to a mutual termination right now where the seller agrees to go ahead and give us our earnest money back now. But the incentive for the seller is the seller can go ahead and put their house back on the market and sell it to someone else. So if that is the situation, then I would do agent to agent communication is not binding upon the party. So whatever you and the other agent work out, don't rely on that for the protection of your parties. You would use a mutual termination and release, because when you use a mutual termination and release, it's not terminated just upon one signature. It needs both party signatures for the termination. And on that mutual termination and release form, you have a thing where they have to agree to the disbursement of the earnest money, and if either of the brokers agree to something. So if that's the situation, again, there's incentive for the seller to go ahead and terminate it early, versus the buyer just hanging out there for days and, for 3 weeks or whatever. But I would use the mutual termination and release.
Okay, and with the mutual termination, there's no responsibility for them to be responsible for unpaid commissions, right?
On the mutual, you negotiate that, either zero or you put something in. On the mutual termination and release, there is a place where you fill in earnest money between the buyer and the seller, and any commissions between any of the parties and the brokers. Could be zero.
Okay, so I've actually never had a contract expire. So it sounds like in this situation, since we don't want to unilaterally terminate, if we don't agree to the mutual termination, we wait for it to expire, and then the next day you use a unilateral termination, or which termination form would I be using then?
Not unilateral.
So if the contract just expires, like if it doesn't close, you wait until the next day, and then you would use the unilateral, because the other party is probably not going to sign it. You would use the unilateral, but you have to wait through 11:59 p.m. that night. So there's a lot of sellers that were expecting to get earnest money that defaulted because the buyer failed to close on the closing date, and the seller sent the TNR at 5 o'clock instead of the next day. So instead of the seller getting the because it just failed to close, the buyer never showed up at closing. Instead of the seller getting the earnest money as liquidated damages, they just now defaulted and the buyer gets the earnest money back. You have to wait till the next day. You send the unilateral. And then same thing, if the other party doesn't sign the agreement to disperse the earnest money, then the holder gets to go through the 10-day process.
Okay, thank you very much.
You're welcome.
Dana, what's going on? There's I just had a listing where the seller tested that, because this COVID is causing all kinds of new stuff here, and he tested positive. So now he's got a 2-week quarantine. So every date had to be pushed.
Well, you need to negotiate that with the parties. There's no automatic extensions because of COVID unless the parties agree to it by a special stipulation, exhibit, or amendment.
That's what we did.
GAR put out all those special stipulations back in the spring, but if that's not in a contract, there's no automatic extension because somebody has COVID or the flu or a heart condition or congestive heart failure or cancer or diabetes or has been in a car wreck, or there's no automatic extensions for physical health issues, regardless of what that is. I mean, they could have the plague, they could have mononucleosis, they could have whatever. There's no automatic extensions. It has to be agreed to either in the original contract accounting for any extensions for that reason and notices given for that extension and timeframes, or it has to be an amendment. If a party has COVID and can't come to closing, I mean, first thing, check with the closing attorney and see about any kind of virtual closings or delay or something like that. But if the other party doesn't agree to a delayed closing, then that party is going to default by not being able to show up at closing, regardless of the reason.
Well, this is not just for the closing. I mean, we couldn't even have the inspector come in and, you know, the appraiser, you know, it's a lot of that
Yeah,
couldn't
then the
happen. It
buyer,
was at the beginning. So-
then if you can't amend the contract to extend those timeframes, then the
Yeah,
buyer
we did.
then the buyer is either buying the house as is, or the buyer has the option to terminate. There's
Yeah.
nothing automatic just because of any health issue. Right now, COVID, but even after COVID or before COVID, there are people that were in car wrecks and in the hospital incapacitated, had brain
That's
aneurysm,
true. Yeah.
had some sort of other infectious disease.
Mm.
Regardless, there's no automatic anything. It has to be, it's a contract between a buyer and a seller, and they need to agree on all the terms. And you don't have to agree to those terms if you don't want to. The seller could say, "So sorry, I hate it for you, buyer. Guess what? I got another offer, $10,000 more. Feel better, terminate." Yes.
I'm sorry, I'm interrupting you, but
Hi, Lynn.
hi, sweetie. I'm so happy when I hear your voice. Darling, what is, like you said, always do variable. Should we be starting, given that 2021 is going to continue this, always putting an amendment for extending?
I don't.
Well, you know, you were telling this agent lady person with a nice smile, if it's not signed, it doesn't exist.
Right.
And you said always do variable no matter what. You think we should be putting in this extensions shall be honored by all people with illness related?
I don't know if you're going to get parties to agree with that. No, well, a couple things. Number one, okay, let me go back to the variable rates commission. I would always put yes in that, because in general, even throughout the course of negotiations, there are a lot of times when the commission does vary from what was agreed upon in the listing agreement to make a deal work. And just parenthetically, and I should have said this earlier, if you're going to do that, really, you also need to then go back and amend, like let's say you end up contributing part of your commission to buy a home warranty or a rebate, blah, blah, blah. If it wasn't already agreed upon, you really then need to go back and amend your brokerage engagement to reflect that. But that being aside, that's my comment on variable rate commission. Regarding the extensions right now with respect to COVID, I'm going to defer to your broker or an attorney for how to write that. And I know GAR did come up with several COVID related stipulations. The reason I'm saying that, Lynn, is there's a lot more than just putting in there shall be extended. You need to put in anytime.
I know. Let me put it this way. I didn't ask it well.
Okay.
Assuming, because I'm the broker, so I don't have anyone to go to. I go to Weissman and I say, how should this be in there? They say, well, GAR put something in. Okay. But should we, when we get the verbiage approved, should we be including something all the time?
It's up to your client. It's,
Okay.
I mean, as a broker, that could be a broker decision that you make for you and your agents. Just like some brokers require the lead-based paint exhibit to be used on any and all contracts, regardless.
Which I do. I do that.
That would be a broker decision to make. You know, depending on this, what's going on in the world. And I would go back to GAR and look at those COVID sticks that they sent out back in the spring.
Okay.
But that would be a broker decision. And honestly, I'm trying to think of how to, you would probably still want to address that with your clients, because there are a lot of issues that we look at as a real estate agent with respect to a transaction and a contract where that issue might be extremely politically charged, and may not want that addressed in a contract for a variety of other reasons. So
Got it. Got
even
it.
if you choose to make that a brokerage policy, you probably would want to have that discussion with your buyers and your sellers regarding including that on a case by case basis.
Yeah, what
And
we
I
did,
really learned a lot today.
Yeah.
This coming soon thing is such a can of worms.
yeah,
Yeah.
that's bad. I don't use that.
It is used incorrectly by many agents and brokers in our
Mhm.
area. It's
Mhm.
used as, I started to say this, I don't think I continue this. I don't really know why you're using coming soon right now in this market. You put it on the market and you're sold.
Exactly, it's gone soon.
Now, the thing I love about the new listing agreement is it does have now a place to sign it, and then the marketing commencement date, because you want to sign it when you've got somebody willing to go under agency, become a client of yours. But just because they sign it, the FMLS rule is you have to put it in FMLS within 1 day of the marketing of it. So now you still have to sign it, but yeah, I don't understand the coming soon, because I absolutely see it if you're trying to generate interest. There's so much interest right now. It's a whole different kind of stress. It's stressful when there's no buyers, and then it's stressful when there's too many buyers. So
It's more like it's leaving soon.
that's funny. But coming soon is used incorrectly by numerous agents and brokers in the Metro Atlanta area right now. And
Like where I live, it used to be a $25 fine if you did that. And if they're selling a $400,000 house, what do they care about a $25 fine? So they put it in, but I don't think people have taken the time to learn the restrictions on it.
Yeah.
yeah, and yeah, absolutely. It is the bigger issue is fair housing. Not only is it a potential fair housing violation against you and your license, but your seller. If you're coming soon means it is coming soon. It is not available for seeing right now. There should be no buyer, potential buyer, that sees that property. It is also not supposed to be marked. Well, there's nobody that's supposed to see that property, because if you only show not only fair housing, but all of these issues we're talking about now, if you only show it to yours, it will just a whole variety of issues, but especially with the fair housing. No, it wasn't made available. It wasn't made available to me because I'm in one of these protected groups. That's a fair housing violation. Do you have a good argument against that? Well, guess what? People walking by saw, well, I don't live in that neighborhood right now. That neighborhood is this, that neighborhood is that. You've got to be extremely careful with fair housing violations. And you guys, there's a lot of people out there that know these fair housing laws a lot better than you do, and they make their living by winning these fair housing laws. Not only that, HUD has secret shoppers. HUD will call, it's especially rampant with leasing agents and rentals, but even for selling property, HUD has secret shoppers that will call you up to make sure you are not violating fair housing laws, and you don't necessarily know.
Now, Diana, does this new listing or sellers agreement, is that that doesn't go into effect until 21, correct?
2021, and my understanding is these forms will be available through Remind Docs and Transaction Docs, Transaction Desk as of January 1st, 2021.
Okay. Thank you.
You're welcome.
Boy, that's a lot. It's a lot. It really is.
It's a lot, and it's not even a whole lot to the purchase and sale, but
yeah,
they're designed to protect us as agents and brokers, and to clarify things regarding the actual brokerage relationship, which creates the client, a brokerage agreement, which creates the client relationship.
Yeah, but these sellers, they just sign, they don't really even read it. They just
Well,
sign.
and Vanessa, that's why they added that above all the signature lines. You, public, you have read this?
Yeah,
You
yeah.
affirm that you've read this?
Yeah.
You understand this and you agree with this?
Dana, may I say something to Vanessa?
Yes, absolutely.
Hi, Vanessa, I'm
Hi,
Lynn.
Lynn.
I've had the privilege of following Dana for several years. I got yelled at by an agent because I make my clients sign initial every single page of everything. Everything.
It's a good
Because
idea.
I tell them, remember, when you put your initials here, you're saying that you read it.
It's a good
And
idea. Yeah.
I don't know what Dana's opinion on that is, but
Well,
I
I
just
mean,
feel
I've been
bad
in
that
league,
people are
I've been in law for 20 years, and that is a very good thing to do. I had a
because
client.
Dana, no one takes responsibility.
Yeah.
Well, here's the thing, Lynn, that is going to protect you. That is going to protect your license, especially with respect if you are ever involved in a GREC hearing or in an ethics hearing or even an arbitration case. But it doesn't necessarily hold up legally. Georgia is not what's called an initial state, meaning
Okay.
if there is a place for an initial and it is not initialed by all the parties, it does not render that contract or that part of the contract voidable because Georgia is not an initial state. For example, in your purchase and sale agreements, it references, you guys know the page right before the signature page where it references exhibits.
Yes.
It says, the verbiage says, the following exhibits that are marked are incorporated by reference. That is done before the signature.
Right.
So even if you don't have your client's initials on the exhibits are still part of the total agreement because they were referenced in the purchase and sale prior to the parties signing the purchase and sale.
Now, I think that,
On the RE forms, for example, there's an initial page, there's initial space on every single page. Well, if one of the parties misses the initial, it does not render the contract voidable or non-enforceable because of the law in Georgia. Now, is it a good way to demonstrate to your broker, to the public, to the co-op, to a judge, to an arbitrator, that yes, in fact, the public did see this form. They did initially. Did they read it? I can't, I don't know if they read it or not, but I've got proof that not only did I present it, they read it because here's their, they had the opportunity to read it because here's their initial. So I hope that helps, Lynn.
I think those initials, I think the initials to me, what Lynn is describing is more for just a listing agreement, not the whole package. The contract
No, I
package.
do the whole package.
Oh, I don't do that. Oh, yeah, I
I do
wouldn't.
the whole package for one reason. People don't want to take responsibility. Dana, you change what I say if you don't like it. But people don't want to take responsibility. They have a 20-second concentration. And if I say to them, now remember, every time you initial it, you're saying to whoever sees that page, whatever page it is in this 28-page contract, that you've read it, because if you hadn't read it, of course you wouldn't put your initials on it. Excuse me, it's bullshit, but it makes them pay a little more attention.
I had a client that he's an engineer. And when it came to the seller's disclosure, he checked everything that he thought he was taking with him instead of everything that was staying in the house. Oh, God. And of course, this man's an engineer. I didn't look it over, his disclosure. And so when I got ready, I looked over the contract. I said, wow, you do. She loves it.
Thank you guys so much. Merry Christmas, everybody. This is,
Merry Christmas to you, honey.
like I said, this is going to be the most celebrated New Year's Eve of all
Yes.
time. So
Goodbye 2020, for real.
you guys, there are buyers and sellers that need you to bless them with your license, your knowledge, your
Yeah,
expertise, and
yeah.
your desire and your enthusiasm. Please go out there and bless them. Thank you guys so much. I appreciate your time
Yeah,
and attention, and happy 2021.
Yes, indeed.
Bye,
And a
everybody.
safe one. Be safe too.
Absolutely.
Yeah.
Thank you guys.
Take care.
Bye.
Bye-bye.